Yes,
Lordship, there's just a minimal half point left of those 10 points yesterday. I had not read 368. Just turn to it for half a minute.
of the Constitution.
Of the Constitution. The amendments required would be quite merely the entries. You know,
It was 3/4 of the
3/4 of 2/3 of Parliament
and
and half of the states.
yes, ratification of this.
That second part is even more cumbersome. Just turn to 368, the longish clause 2. My lord has got.
First proviso. C.
Yeah. An amendment will be made only by the introduction of bill from the Parliament. When the bill is passed by each house by a majority of total membership and majority of not less than 2/3, they will also get 2/3. It shall be presented, who shall give an assent to the Constitution, provided, my lord has got the proviso is addition, that if such amendment seeks to make a change in C, any of the lists in the 7th schedule, even list 1, the amendment shall also, the word also is important, require to be ratified by legislatures of not less than 1/2 the states by resolution to that effect passed by those legislatures before the bill making such amendment is presented for assent. There's one last thing on yesterday's. I read verse 8 of my WS yesterday. I somehow omitted to read 26 and 27, which is connected. So I can just wrap it up by asking my lords to go to my submissions 26 and 27. That completes those list of points. As Justice Shah said, I'll be giving that list today, typed out. That's it. 26 and 27, just very short paragraphs.
Yes.
The contention that entry 41 is not available to UTs with legislature is belied by existing precedents relating to functioning of such UTs and their legislatures. 26. The argument that UTs, even with legislatures, cannot have services of their own and therefore do not have entry 41 available is belied by the manner in which UTs with legislatures, including Delhi, have functioned so far. Now that this 27 is important, it's not going to take your options there, it's at bookmark 50, but reading it here itself. It is settled law that creation of posts and terms of conditions of service relate to entry 41. Yesterday I showed you several acts. They all relate to this. The citation is para 6. It is primarily the legislature, namely Parliament or the State Assembly, in whom the power to make law regulating the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or state is vested. The legislative field indicated in this article is the same as is indicated in entry 71 of list 1 of the 7th schedule or entry 41 of list 2 of that schedule. 28, my lord, is ready. My lord remembers those Delhi Fire Act and several other acts I showed. So I'm not reading that. So these are ballots. Each para 28 is each manifestation of entry 41 being exercised. I'm sorry.
Has the UT constituted any services at all? Like central secretarial services you have? And of course, the All India services, and then the Dimanshu services.
Denics.
Are there any Denics? Yes.
Denics.
Now it's Denics. Are there any services constituted by the state at all?
Well,
Any act passed with respect to the state?
No act is passed to suppress the
Not even.
But all these acts create services. I mean, your lordship is asking, is there a services act?
General.
No, but there is no need for that's why I said Delhi Minorities Commission, Delhi Lokayukt Act, Delhi Fire Services, all of them create a whole staff setup, a whole services setup under that.
No. Council, the question is,
309.
any of the law related to entry 122 and 28, 1, 2 and 18?
The power to create, but I'll tell you, just kindly tell me, if you answer.
No, nobody can dispute the power under entry 41.
Yes.
But the question is with respect to any law laid down or any law enacted
Yes.
with in connection with
Yes.
Entry number 1
Now-
to and 18.
For example, section 6, 7, 8, 10, 11, 14, 16 and 63 of Delhi Fire Services Act. It creates posts, it creates employment terms, everything. They have no power to create that unless the power is traceable to 41.
Well made.
What my lord is saying is a separate act.
Slightly different thing.
Point is taken.
That point is, you've already made.
Correct.
That there are several enactments of the Delhi Legislative Assembly, under which posts are created.
41.
Therefore, that's relatable to NC.
So that's one answer.
But but
There
the
is no
point
separate act which says
Right.
Delhi Subordinate Services Act.
different. The point is a little different, which is that in respect of subjects which relate to entries 1, 2 and 18, if you are creating posts, if you are creating services, then perhaps.
Whereas there, your lordship will take it. Your lordship asked a question yesterday. A, it doesn't arise here. B, I am not asserting legislative or executive power to create posts for land, police and Malas.
Then there's
So
no.
that part, I may assure my lord. I mean, I'm sorry, I misunderstood the question. As your lordship may take it. A, it is a hypothetical question. In some Malas case in the future, your lordship will decide. In this case, I am not asserting
Correct.
any right, legislative or executive, to do something for 1, 2 and 18.
Including creating of the post,
Yeah.
Including Malas related.
including the services with respect to 1 to and 18.
Whereas including services meaning creation of post directly relating. If it is Malas, everything is related to land, something is peripherally otherwise, no, I'm not asserting. Malas, take example, land revenue. Land revenue is Delhi is having all the stuff. But that doesn't mean that land I'm asserting. So Malas, I'm strictly relating to 1, 2 and 18, which is amplified by 64, 65, 66 also.
Land revenue is a separate entry anyway.
Yes. So therefore, Malas, that will not trouble your lordship.
Anyway,
I am saying the reverse point now. I am saying that whatever I have created, unrelated to 1, 2 and 18, is relatable only to 41.
My question was,
Ah.
with respect to unrelated to those three excluded provisions,
Yes.
the general services, is there any general law that
That's
you
the
have
second
made?
question. There is no general law.
Number one, are you also regulating the services under 309 rules? Have you made 309 rules?
Malas, we have not.
I'm just asking you.
Answer is actually no. There is no general act saying Delhi subordinate services or Delhi something.
So therefore, with respect to the disciplinary or other aspects relating to that, which are the rules which govern them?
Exactly. I'll tell you. We have mentioned them in my
Called the CCS, CCA rules.
Yes.
Do they apply?
Let me explain to you.
Dr.
So-
So, before you explain,
Yes.
what is DSSB about?
I beg,
DSSB, Mr. Mehra will assist you.
which,
DSSB, Delhi Subordinate Services Board. Mr. Mehra, what's that about?
That's about, Miloj, all these,
Appointments of what cadre?
Miloj, I think it's a,
It's a board for appointment.
it's a board, Miloj, we'll just find out, we'll take instructions.
DSSB.
But there is a DSSB in Delhi, which has been functioned for.
So that's how you appoint teachers, that's how you appoint other staff through the Delhi service selections. About
Just as. I have understood my lord, is services like say in Gujarat administrative services, Gujarat subordinate services, etc.
There's nothing
There is
like that.
none in Delhi. Lord, all employees, right from All India services till till downwards, my lord, except DAS, which your ladyship said, are recruited by UPSC and governed by the central laws and the rules framed by the Honorable President in exercise of proviso under Article 309, which I'll explain. So far as DAS is concerned, my lord, Delhi subordinate services, that is, the selection is not by UPSC, but by a separate service selection board, which is under the President of India. So for Delhi, there is no separate act providing for creation, selection, abolition, or departmental inquiry or any other service related issues by Delhi. Factual. Then whatever are submissions I'll make.
Now, Malas, so let me just summarize. About the specific case of DSSB, we'll get the act and read it to your lordships. Number one, I am not asserting any right to 1, 2 and 18. That part is question 1, which came yesterday also, and I'm making that. Question 2, there is no separate act in the manner in which my Lord Justice Narasimha put the question, answer is no. Point number 3, the issue is a little different and it is being conflated. There are 2 services we all accept, All India Service and one is central government or DANIX service. All such services are dual services. They are joint cadre services. They cannot operate without a state union territory on one side and a central government on the other side. That's important. In a joint cadre service, otherwise, because your lordships would have no state allowing a joint cadre. The post is an all India service, but is always anchored in a UT or a state. That's the point. State is just like UT for purpose of anchoring it. Number 2 and number 3. Under that, once the overall board allocates Mr. X to UT Delhi, that person is based in Delhi, belongs to, for example, DANIX or belongs to DANIX. And his transfer, control, dealing with him, all comes under the existing system with the Delhi government.
Now that part,
Yes.
under which all once allocated to a state
Yes.
or union territory, all incidents of the service fall within that state or union territory.
Yes.
That would be referable to that legislation under which that service is created. Now
There are-
IAS, for IAS,
There are only 2 models. One is All India, one is the DANIX and DANIX.
right. Now therefore,
They all have cadres in state.
therefore, we will have to look at the rules under which that service is created.
Some,
Admittedly, these services are created by either a central legislation or by rules and are governed by rules framed by the government of India.
so that we've dealt with in my submissions.
So therefore, we will have to look at the IAS rules. We'll have to look at the IPS rules and the rules which govern DANIX and DANIPS.
So that I will be showing to your lordship in my. But one thing I must say, apart from your showing that, subject to my lord seeing it, I'm on a slightly more general principle. None of those rules can and do factually suggest that once your lordship locates an anchor in a cadre, the person, as your lordship says, is reverse. He is on deputation to center. He is very, very rarely in deputation to another state. I don't know of any.
Normally, in the case of a state,
Yes,
once a person has been allocated to a cadre,
yes.
whichever state it is, then that state government decides on the transfers, postings.
It's exactly the same in the 3 cadres here, Manus.
Now, will the same principle apply to the union territory like Delhi is a question?
AGMUT, DANIX and DANIX. They are the 3 principal.
Right.
It's the same. They are allocated
But
to
that's,
us.
Dr. Simi, that now when you say it's the same, that's a matter of your ipsedixit.
No, that,
We want to see, we want to
that I'll be showing the rule. I've not come to the rule.
statutory provision because they will shed light on what it
No,
is.
therefore, that I'll be dealing with. I'm just saying, your lordship would have to have a very different kind of, I'll be showing the rule. Lordship may take it, I'll be coming to the rules. But your lordship would have to have a very different kind of an exceptional service created for the states, where there is a deputation to the center and a cadre for the state, versus wherever a UT comes, there is no cadre, there is no deputation to the center, and a specific provision created to have a different scheme. That is all I'm saying at the moment. That is not so. Your lordship is not.
We want to know.
I will show that.
Because that statutory regime will be of some significance actually.
That is
because
dealt with.
what else? See,
That is fully dealt with by. So, one is lordship. just take
in
that.
your turn, before you conclude
What
today,
we will
can you
see
show it
that-
to us?
No, I'll be coming to that. It's directly dealt with my submission.
What
Well,
we will,
that is,
what we will see in that is, we want to know who will be the cadre controlling authority, which the rules will specify.
as in all states, same thing.
We'll
Same
see
thing.
that.
I'll show that. As in all states, there is no special scheme created for UTs in that, which inhibits or prohibits what I am asking for, namely control of the civil service serving my state or my UT.
Right.
That's the only point. Now, your lordship has done with yesterday. My next submission are a few submissions on the Balakrishnan report. I've got about 6-7 points. I'll deal with them one by one. The first submission today is on Balakrishnan report. That what I've just said was about yesterday. Now, this Balakrishna report was nothing but it was headed by somebody else, by Justice Sarkaria earlier. Then he took some other commission. So Mr. Balakrishnan is an advisor to the Home Ministry. He's chaired it. Now, there are just 4 or 5 reasons I want to put out in sequence for your lordships. Reason number 1 is the first reason my lord saw yesterday why the Balakrishna report is of not much value.
What does the Balakrishnan report really say on services?
Yes. I'll be reading the statement. They said, Manoj, in para 8.1.2. I'll be taking a lordship to it in a minute. Let me just give a lordship the submission.
81.2 of your submission.
No,
No,
the report.
no. In the Bala report. I'll show that. So, Manoj, my submissions are before I take a lordship there. Firstly, Manoj, Balakrishna report is of no relevance today because of the first set of reasons my lord saw yesterday. A constitutional amendment came with limited A to 3 exclusions, only 3, 1, 2 and 18. B to discretionary powers and C to reference on disagreement. Balakrishna report, which pre-exists, cannot go beyond that. Number 2, the second reason why the Balakrishna report is wrongfully made the basis of the impute notification is that it makes an error saying, fundamental error, conceptual error, that services can be only of 2 kinds, one under the union and one under the state. And there cannot be services under the UT. This is a fundamental conceptual error. Dr. Smith, note the point, I'll show the pages.
Will you repeat yourself, Dr. Singh?
I beg pardon?
You please.
Yes. So the first reason is that Balakrishna never anticipated that the constitutional amendments structure of 239AA would exclude only 3, nothing else, and 1 discretionary and 1 reference to disagreement. So, Manoj, it has been overridden, it has been supplanted by the constitutional amendment. It can have no relevance today. That is the point your lordship covered yesterday with me. The second reason why the Balakrishna report is of no significance is because of a fundamental conceptual error that services will be either of the union or of the states and no third entity, UT, can have services. The third reason, I'm just itemizing it, you should find it convenient, then I'll show the pages. The third reason is that the Balakrishnan report, in so coming to this fallacious conceptual conclusion, completely ignored, if your lordship were a bench, it would be called per inquiry. Bala report is not a bench. A 4-judge judgment of your lordships in Prem Kumar, which specifically reversed the High Court, specifically, which held there are only 2 services and UTs can't have a service. Completely Manoj omits mention Prem Kumar Jain. It shows Manoj that Balakrishna is very infirm on this aspect. Fourthly,
Yes.
which is important, the basis of Prem Kumar Jain is the joint cadre point I just said. And specifically, it contemplates that a joint cadre will be between a UT and the central government. Oh, sorry, a UT and a state. Or it could be theoretically 2 states also. And finally, fifthly, it is for this combination of reasons that your lordships in paras 276 and 277 of the Constitution bench specifically say that we will not take the aid of Balakrishnan, and to quote and unquote, there is no necessity to be guided by the report of the committee. This again is, Malas, a covered area. Your lordship doesn't have to go beyond or before or after. Now just see these 5 points very quickly. First point, my lord asked me, where is the Balakrishna report on this subject? That is in your lordship's first compilation.
2366.
Para 8.12. And that is your lordship's larger page, 2438, 2439. Again, there'll be a 4-page difference maybe for the index. This is the relevant part of Balakrishna report 8.1.2.
2370 it starts, right?
Bookmark.
Where you want us to see?
Bookmark.
Page,
Bookmark 33.
At 2443.
the report starts as per your index at what page, please? This is.
243.
2366 it starts. It's not relevant, Manoj, because Lordship goes, it's a long report as usually reports are. Lordship may straight away go to 2, 4. That's right. So 8.1.2 in that page.
8.1.2.
Once my Lord has it, I'll read it, please. May I read, please?
Yes.
May I read? Entry 41 of the state list mentions State Public Services, State Public Service Commission. Obviously, this entry is not applicable to UT because it mentions only state and not UTs. This is the binary distinction. Very simplistic. This is the fundamental error of the input notification. It mentions state, can't cover UTs. This view is reinforced by the fact.
Don't mind if you can read the first para also.
Very
You
well.
don't have to.
Certainly, I'll read.
8.1.1.
I'll read from 1.1.
There is a
The question of control over the service personnel and the input notification, nothing but picking this up and writing it in the notification. This Balakrishna report, which has been rejected by our Constitution bench, is the pickup in the, virtually reiterated in the question of control over the personnel serving in the Delhi administration was examined by us carefully in view of its obvious importance in the context of evolving a scheme for representative form of government of Delhi. When dealing with the legislative powers to be conferred on the proposed legislative assembly, we recommend that such powers may extend to matters in the state list and the concurrent list. We have already explained in the preceding chapters the need for restricting such powers to matters in those lists in so far as they are applicable in relation to UTs. We have also explained the scope of important reservations in this behalf. Entry 41 of state list mentions,
Yes.
Entry 41 of state list mentions state public services, state services commission. Obviously, this entry is not applicable to UTs because it mentions only state and not UTs. It's very simple, Malaz. Binary bifurcation.
This line is been criticized in the Constitution.
This has been criticized, and I will say
In fact, yesterday,
directly, Manoj, directly.
Mr. Solicitor expressly said that he's not relying on that.
I'm not relying.
No, that's the beauty of it, Manoj. That's the
I
beauty.
will rely upon it for giving a context as your lordship.
Yes, that is the beauty of
It has
it.
to be done contextually. That's all.
Manoj, that is the beauty of it. You cannot rely upon it, so you rely upon it in a different way.
But it doesn't really matter.
What has happened,
It's a
Manoj?
matter of interpreting. We will look into it.
The point, this exact paragraph, 2 sentences of this virtually are exactly the basis of the input notification.
But
Without saying that I rely on Balakrishna report.
Balakrishna's report was prior to the Constitution Amendment.
Yes,
That cannot now determine
That's right.
the nature of the amendment. We have to decide it for ourselves.
Manoj, therefore, my lord is
At
great.
the highest, this is like, it's not even statement of objects and reasons of conveyance.
No, but Manoj, there is one more thing.
These are preparatory documents.
Entirely. I bow down entirely. But in my learned friend's written submissions of 90 pages, Balakrishna report is given pride of place. I mean, I can only go by what is given to your lordships, fellows. Number 2, Balakrishna report, the essence of 8.1.2 is found in the notification. Now,
You have shown us the para and you have told us why it should not be
so
written.
you are saying that I'm not
It's not
lying by
like
calling it
a
Balakrishna.
pedestal that we have to,
Yes.
take, it's not like a statute or something.
Exactly, it's an
External view of an officer was,
Well, ultimately, the reasoning is the same. There are 2 services, central government and state. There is no UT service.
but another thing, merely because Balakrishnan is wrong, that doesn't mean that the notification is bad.
No, obviously not. What is that?
Whether the notification is bad or not, we have to decide.
I am showing, Malaz, the entire case In the written submissions, my learned friends was saying today it doesn't realize written submission has got 20 paras of allocation report. That's all right. I mean, ultimately we have to meet a case. Now,
Neither the notification is not really the subject matter, it's the constitutional interpretation. That's what matters to us.
In any case, Dr. Singhvi, the very para you're reading goes on to state that the reasons that weighed with that in that report was Article 239. There was no 239A anyway.
that I said, Malas, that they are relying upon the. Now, Malas, kindly come to Prem Kumar Jain, 1976, 3 SCC 743. Bookmark.
Page.
This is, Malas, your lordship's page 4142, maybe 4146. Because of
1976.
well, this is 4142. The citation is 76 3 SCC 743. Four judges, your lordship sometimes has.
Violation page.
4142, which could be 4146 with the index. Bookmark is 52.
There used to be a lot of four-judge benches, particularly in the
Yes.
50s or 60s. So if there was an odd judge, you had to put him in the bench of three, so it became four. That is the only reason why four sat.
But there is nothing really wrong even today, Wallace, if your lordship does have for whatever exigency. Your lordship doesn't normally have, but there is no.
Practical problems, sir.
There may be some dissent, etc. but that can.
The reason is your lordship's workload is so much more that your lordship would rather have two benches of two each than one of four.
Absolutely.
Because the one of four is neither a constitution bench nor a three-judge bench. So why should your lordship, Wallace, if in that sense, waste two judges in a bench, if I may use that phrase? Now, Wallace, Justice Shingle starts the judgment. These appeals by certificate are directed. This is important, Wallace, what they reversed from the High Court. That's why I'll read para 1 and 2 first. These appeals by certificate are directed against the judgment of Delhi High Court, 25th September, allowing civil writ. The High Court has quashed the order of the central government notified in so-and-so Gazette, dated January 13, as well as the scheme for the formation, kindly mark this, as well as the scheme for the formation of a joint cadre of the IAS, hereinafter referred to as the service, for the UTs, very important, and has held that the formation of the Delhi Himachal cadre of the service was ultra vires the constitution. On the ground that Himachal is not a state. That's the short point. And directly therefore relevant. Directly the principle is relevant. A new cadre of the service was constituted for the UTs of Delhi and so that time when Himachal was a UT. And recruitment to that cadre was made directly without complying with the requirement of Rule 4, Indian which prescribed. The rules were amended on December 21 by providing for a joint cadre in relation to the Union Territories and the Northeast Frontier Agency and the central government formulated the aforesaid scheme to extend the Delhi Himachal Pradesh cadre, that is the joint cadre, to all UTs by absorbing the officers of that cadre and by appointing to it officers of the Indian Frontier Administrative Service and all other Union Territories at its initial constitution. The joint cadre for all the UTs was brought into existence from January 68 under so-and-so, dated January 13. Now let's kindly read. The petitioners in the High Court challenged the creation of the new joint cadre for all the Union Territories and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of Article 312 and the All India Services Act of 1951, as it was not common to the union and the state, inasmuch as a UT was not a state. And the recruitment of respondents concerned to the joint act and now your lordship may come straight away to para 5. They start with Balus 358 of the General Clauses Act and all that. I will not read it, your lordship is aware of it. Straight away come to para 8. May I read? It follows, therefore, that as from November 56, when the Constitution's 7th Amendment Act came into force, the President had the power to adapt the laws for the purpose of bringing the provision of any law in force in India into accord. It was under that power that the President issued the adaptation of laws order of 57, which, as has been shown, substituted a new clause 358 in the General Clauses Act, providing inter alia that the expression state shall, as respects any period after the commencement of the Constitution, mean a state specified in the first schedule to the Constitution and shall include a UT. State shall include a UT. It cannot be said with any justification that there was anything repugnant in the subject or context to make the definition inapplicable. By virtue of 372A, it was that definition of the expression state which had effect from the first day of November 56, and the Constitution expressly provided it could not be questioned in any court of law. The High Court therefore went wrong in taking a contrary view and in holding that UTs, this is the finding, High Court is reversed. The High Court therefore went wrong in taking a contrary view and in holding that UTs are not state for purpose of 312 and the preamble to the Act of 1951. That was why the High Court erred in holding that the definition of state in the Carter Rules was ultra vires, the All India Act, and the Constitution, and that the Union Territories Carter of the Service was not common to the Union and the states. It's common to Union and states means common to Union states and UTs within the meaning of 312, etc. And the central government could not make the IAS rules, etc., as there was no government, as there was no such government in the Union Territories. Now, let's the one is Balakrishna report. Oh, I'm sorry. Sorry. One is Bala report.
Yeah, state.
parts of the constitution which for specific purposes define things. There are many other section clauses I have noted. For example, your lordship got GST in 2016. Your lordship specifically added GST provisions to make UTs covered. That was only for the purpose of GST. Otherwise, again, it's the same thing. Your lordship had to amend the entire 7th schedule. There are other provisions elsewhere for specific
So
purposes.
246A came in, 269A came in.
Had to, Malas. Otherwise, your lordship would have a same that 368 amendments and all that. All that. Therefore, Malas, now, Prem Kumar, one is Balakrishnan. Your lordship has observed that it is prior and report doesn't bind your lordship is interpreting, so I'm leaving Balakrishnan. Second is the premise underlying the notification of only 2 services. That is also wrong, is what I'm saying. The premise underlying, forget Balakrishnan report, I understand, the lordship, there may be an error in relying on something.
Of course, you have Prem Kumar Jain, but then you have a 9-judge judgment in NDMC which
Coming
says state
straight
does
away.
not include a unit.
No, straight away, Manas. NDMC I'll be dealing with. NDMC doesn't deal with this subject. Your lordship, the beauty of this is, NDMC is dealt with by your lordship in the constitution bench.
I read.
Separately, NDMC is a totally different question. That's one of the points I'll be dealing with. Your lordship may take it. NDMC does not at all dilute any of my arguments. And your lordship relies upon NDMC to come to the conclusion. Therefore, Manas, if your lordship in a constitution bench explains these judgments, then how many times? Of course, the iterative process can go on. Your lordship can have 7, 9, 12, but that would not be really, unless
Anyway,
something
Dr. Singh,
glaringly wrong is said by your lordship.
all this in the context of the Balakrishnan report.
No, I'm not leaving the Balakrishnan. I'm saying the premise of the notification is also the same. That there are 2, forget Balakrishnan. Manas.
Yeah.
The premise of the notification that there are 2 services is what I'm assailing. I entirely take the cue from my lords that Balakrishnan, though it finds some 10 paragraphs in my learned friend's written submissions now and today, but since he disclaims reliance on it, I also leave it. But well, certainly the basis of the impute notification is as a binary bifurcation. That is wrong. And Prem Kumar Jain also says it is wrong. That's all I'm saying. Now, Maharaj, kindly conclude this part with your lordship's findings on this at para 276 and 277, just for completeness. I know your lordship is not relying on it, your lordship should know these paras. Of the constitution bench at 4789. 4789, para 276.
47.
8-9.
That could be 4793. It is not as if my learned friend's client has not been relying continuously on Balakrishna, including today's written submissions. Not, after all, lordship is not devoting all these paras for nothing in your judgments.
Para?
276 para is at
Yeah, got it.
4789.
Got it.
Internal page is 643 of the SCC. May I read it with your lordship's permission?
Yes.
Yes.
We had stated earlier that Mr. Maninder Singh, learned additional ASG, Additional Solicitor General, had urged that the report of the Balakrishnan Committee should be taken off as an aid to interpret the constitutional provisions. And he relied on 7, 8 cases. And then, Malas, they quote from one of those cases, 8 cases. 277. There can be no quarrel about the proposition that reports of the committee enacting a legislation can serve as an external aid for construing or understanding the statute. However, in the instant case, as we have elaborately dealt with the meaning to be conferred on the constitutional provision that calls for interpretation, there is no necessity to be guided by the report. So that covers this point. I now come to a very important, Malas, conceptual issue, separate issue now, which has got some very, Malas, interesting phrases, including from something I found out about the civil service from a UK, very interesting website. So, Lordship may, he calls it serial monogamy. I'll come to that, Malas, when I.
Serial?
Civil servants as serial monogamists. I'll deal with that. Lordship may find it interesting. I mean, it's all persuasive value. Lordship may or not use it, but the title of my submission now is, it's more conceptual and jurisprudential. Westminster model,
Yes.
collective responsibility and aid and advice.
You're reading somewhere?
No, now I am making my next submission. The heading of my submission is the concepts, how they interrelate on collective responsibility in the context of a Westminster model and this aid and advice. They're all the same. Westminster model, parliamentary British, democratic model, aid and advice. Your Lordship may only note the paras, don't read them. Paras 8 to 11 of my submissions deals somewhat with this, but what I'm now saying point-wise will be better to go in that sequence, not the way it is put there. Now, let's the first of the points under this head. I've only got 3 or 4 points here. But it's 239 AA bracket 6 and 4 may be seen. They directly constitutionally ask your lordships to go back to the concepts of collective responsibility and aid and advice. Just glance at 239 AA.
Two.
239 AA. First C6.
Our Constitution Bench judgment specifically refers to aid and advice.
I'll be reading that paragraph. Therefore, this is a very important part of it. Actually, 90% plus of this is covered, according to me, in various paras of lordship. Therefore, I'm under each head. I'm coming to our lordship bench immediately after this. Council of Ministers shall be collectively responsible to the Legislative Assembly. And just glance at 4, just above that. There shall be a Council of Ministers. This is a typical Westminster model, collective responsibility, aid and advice. There shall be a Council of Ministers consisting of not more than 10% of the total number of members of the Assembly, with the Chief Minister at the head to aid and advise the LG in exercise of his functions, etc. Except where he requires to act in his discretion, which you also will not consider. Now, the implications of this collective responsibility, governance in Delhi, is what my lord focused on and will now focus on again in this case, focused on in the 2018. As your lordship goes into this, your lordship will remember my ladder again, which I'm at the risk of repetition again repeating. Collective responsibility in the larger sense is the ladder: civil servant, responsible to the minister, accountable to the minister, minister accountable to the legislature, through the legislature accountable to the people. That's the fourfold arrow. According to me, your lordship's Constitution Bench, especially some very, very interesting paras in the judgment of my lord, Justice Chandrachud as he then, already conceptualize and, more important, synthesize these 3 concepts: Westminster model, collective, and Aden. So let us turn first to that straight away. Your lordship's first judgment, first para would be 318, and that your lordship will get 4814. In fact, your lordship titles it collective responsibility.
1 minute. Correct.
Not only the analysis, but the synthesis is very interesting. The internal page as well as the internal page 668. 668. May I read?
Yes.
Justice Shah has got it. The title is collective responsibility. Justice Murari has got it.
Yeah, got it.
Responsibility. Collective responsibility is a cornerstone of the Westminster model. Initially developed as a constitutional convention in Britain between 1780 and 1832, it began to appear in textbooks in 60s and 70s. In 1867, Walter Bagehot, in his classic work, The English Constitution, called the House of Commons as the real choosing body, which decides the path that the nation would follow. The consequence of such a systemic expectation in the British parliamentary system, Bagehot declared, was that the public can, through Parliament, turn out an administration which is not doing as it likes and can put in an administration which will do as it likes. The responsibility of ministers was set up as their liability to have all their public acts discussed in Parliament. The cabinet was defined as a collective body bound together by a common responsibility. Later, Lord Salisbury formulated this comment. For all that passes in the cabinet, each member of it who does not resign is absolutely and irretrievably responsible, and that he has no right afterwards to say that he agreed in one case to a compromise, while in another case he was persuaded by one of his colleagues. It is only on the principle that absolute responsibility is undertaken by every member of a cabinet, who after a decision is arrived at, remains a member of it, that the joint responsibility of ministers to Parliament can be upheld, and one of the most essential conditions of parliamentary responsibility established. Ministers were liable to lose their offices if they fail to retain the confidence of the House of Commons. In Dicey, it is propounded, well-established law that the Crown can act only through ministers and according to certain prescribed forms, which is absolutely required, the cooperation of some minister, such as Secretary of State or Lord Chancellor, who thereby becomes not only morally but legally responsible for the legality of the act in which he takes part. Hence, therefore, in effect of the Crown itself is brought under the supremacy of the land. Behind parliamentary responsibility lies legal liability, and the acts of ministers, no less than the acts of subordinate officials, are made subject to the rule of law. This fixed the responsibility of the cabinet for the general conduct. Then I'll skip 320, come to 321. Collective responsibility is comprehended in two aspects. Collective responsibility of ministers for the policies of the government, individual responsibility of ministers for the work of their government. Then, Your Lordship has put Geoffrey Marshall's three principles underlined, identifies three strands within this principle. I'll not read it, but they are rather interesting. Confidentiality, unanimity, confidence, etc. Finally, now come to 325.
325, correct.
There is a direct relationship between the principle of collective responsibility and government accountability. The relationship is conceptualized in the Oxford Companion. Accountability can be defined in terms of outcomes rather than processes. It also includes the criterion of responsiveness to changes in circumstances that alter citizens' needs and abilities. In other words, accountability refers to the extent to which actual policies and their implementation, kindly, if you doesn't mind, from my perspective, implementation, which can only be an issue to the civil service, coincide with the normative ideal in terms of what they ought. In this broad sense, accountability amounts to evaluating the nature of governance itself in outcome-oriented terms. Then, what is 327? Collective responsibility also exists in situations where there is no knowledge of the actions taken by subordinate officers, that is, one of the civil service. Governing is a complex affair. Hundreds of officials in dozens of departments may make many decisions on a daily basis. These officials are also part of the executive and ministers are responsible to serve in their departments. Ordinarily, ministers busy themselves with policy. Usually left to officials over whom ministers command little or no oversight. Yet when they act, subordinates notionally do so on behalf of ministers. Ministers therefore cannot seek refuge, nor can they absolve themselves by their officers. Both inside and outside Parliament, they are accountable for their departmental shortcomings. My lords also put it in the old days by a principle of anonymity. The civil servant is anonymous, the buck stops, and the person who takes the rap and the fall is the minister. That's the principle. This is similar to what your lordship has quoted here. Then, I'll skip some paragraphs and come to 331. My lord cites the 7th judge in Karnataka, 1977 for SCC, and then says, explain the substance of a government's collective responsibility. All the ministers are treated as one entity. A government could stay in office only so long as it commands the confidence of majority of the members of the legislature. The government is politically responsible for the decision and policies of each of the ministers and of his department. The sanction against any government action was held to be embodied in the principle of collective responsibility, which is enforced by the pressure of public opinion, expressed specifically in terms of withdrawal of political support. The object of collective responsibility, my lord, then quotes that. Then verse 334.
Effectiveness.
Collective responsibility represents a seminal principle for modern parliamentary democracies. Collective responsibility of the Council of Ministers ensures accountability to the legislature and to the electorate. You are negating bonus for Delhi. If in 239 AA you do not give that collective responsibility, I am giving notionally. But the implementation of that below me by the officers, and then the buck stops with me, that you are taking away.
Read further.
Collective responsibility governs the democratic process as it makes a government liable for every act it does. It envisages that a government works effectively to ensure and fulfill the interests of the public. It purports to ensure transparency in government decisions. Collective responsibility rests on the foundations of constitutional morality, which reflects constitutional ethics. Well, I think this is a very, very plenary and a very inclusive approach by our lordships.
Effectiveness.
Effectiveness, well, implementation, effectiveness, efficaciousness. Why did your lordships create 239 AA? I'm asking myself just for a second. Your lordship had no need to create some UTs with legislatures at all. You have so many UTs without legislatures. Then having created duties with legislatures by parliamentary legislation, why did you make a constitutional amendment? Because you wanted to meet the criticism that the impulse of the people, the will of the people is reflected in the government of Delhi. You therefore give it collective responsibility rightly, in the wider sense in which my lord uses it. You give it all that panoply, but the collective responsibility can't work because efficaciousness, effectiveness and implementation, which must rely only on the civil service, are substantially de facto absent. Now, kindly link it with aid and advice, and I'm very happy that your lordship has dealt with aid and advice immediately in the next section. So your lordship is linking it into a larger whole, and kindly see that. Because that is the aid and advice which I am a UT, no doubt, with exclusions. But I am a Westminster model. I give aid and advice to the LG every day, I am a chief minister, I am a government, I am ministers. We are supposed to give aid and advice. It's not that your lordship is abolishing Westminster by excluding 3 subjects. It may be truncated, no doubt. Truncated doesn't mean dilution to vanishing point or exclusion. Collective responsibility under our constitution is based on a slightly modified version of the British cabinet system. There is a direct relationship between collective responsibility in the form of government envisaged by the constitution. The president was designated as the titular head of the government. The founding fathers and mothers, this one I have not read in a long time. Perhaps now people will be more careful.
That's for the first time, not long time.
No, I'm saying even after this, I'm not.
Yeah.
Sure. The president was designated as the titular head of government. The founding fathers and mothers of the constitution adopted the convention, which made the president generally bound by the advice of the Council of Ministers. This was explained by Dr. B.R. Ambedkar while introducing the draft constitution.
The reason why I use the word mothers is that otherwise the role which was played by many of the women members of the Constituent
Yes,
Assembly
has
not been adequately emphasized.
And they were all
People like
eminent people.
Dakshini, Valyodhan. I mean, they were outstanding individuals in those days.
So many.
These women really contributed to the drafting of the Constitution.
And your Lordship is right.
Extraordinarily, of course, we focus on Dr. Ambedkar, he was the architect, but then we also focus on Dr. Munshi or Sir Alladi Krishna Swami Iyer.
No, relative to relatively.
Iyengar, my lord, even though my lord, recommendations or the suggestions were rejected, but
So many of them.
the person who was a eminent Urdu lyricist, he gave several suggestions, were
The
rejected.
very fact that these women existed,
Right.
some of them with very eminent husbands, but they had their complete own identity in their own right. Durgabai Deshmukh is an example. There are so many more. And they fought for causes, sometimes not in consonance with what their equally eminent husbands were standing for. And therefore they found a place in the assembly. Incidentally, somebody wrote an article, I'm not able to remember, but it's long ago, which has tried to survey and says the vast majority of the world calls it motherland. barring a few countries which call it fatherland. Germany, of course, is an outstanding example, but there are a few others. The vast overwhelming majority is motherland.
But I was referring to Hasrat Mohani. He is very popular as a Urdu lyricist, but he had to say something, my lord, on every subject. Most of it may not have been accepted, but he contributed. He was not a silent member of the Constituent Assembly.
So, whereas your lordship ends on this, after quoting Dr. Ambedkar, just see that quotation, the italics portion, the italicization is by my notes, not by the SCC.
It is merely.
The President of the Union will be generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. The President of the United States can dismiss any secretary anytime. The President of the Indian Union has no power to do so, so long as the ministers command a majority in Parliament. Next line. A democratic executive must satisfy two conditions. It must be a stable executive. It must be a responsible executive. Unfortunately, not possible so far to devise a system which can ensure both in equal degree. In England, where the parliamentary system prevails, the assessment of responsibility of the executive is both daily and periodic. The daily assessment is done by members of parliament through questions, resolutions, no confidence motions, adjournment motions, and debates. The daily assessment of responsibility, which is not available under the American system, is felt far more effective than the periodic assessment and far more necessary in a country like India. The draft constitution, in recommending the parliamentary system of executive, has preferred more responsibility to more stability. And this is not abstract. Your Lordship is quoting and writing this in the context of the NCT judgment. Same 239AA. Then,
Actually, then 343. Yeah.
342, if Lordship will come to us for a minute. 342. Justice Lokur, while delivering the concurring opinion in Navagrevia, opined that the absence of expression is individual judgment makes it apparent that the governor would always be bound by the aid and advice of the Council of Ministers, except in matters where he is permitted under the Constitution to act in his discretion. Collective responsibility and aid and advice are mutually reinforcing principles. That's the linkage, that's the synthesis, which is very important. This is the synthesis. Each of them and both in conjunction affirm and enhance the democratic values on which the cabinet form of government is founded. Collective responsibility ensures that government speaks as one political entity which owes allegiance to the elected representatives of the people. By ensuring that government is responsible in its decision-making to the legislature, the principle of collective responsibility fosters a responsive and accountable government. Now, kindly read. Modern government, with its attendant complexities, comprises of several components and constituent elements. This is important. They include ministers who are also elected as members of the legislature and unelected public officials who work on issues of daily governance. Discussion and dialogue are accepting of dissent. In a system of constitutional governance, collective decision-making must allow room for differences. A synthesis can emerge in government when political maturity and administrative wisdom combine in arriving at acceptable solutions to the problems of governance. Collective responsibility allows for and acknowledges differences in perception and ideology. Yet what the doctrine does is to place a decision taken by a constituent part of the government as a decision of the government. All ministers are bound by the decision taken by one of them or their departments. In terms of its accountability to the legislature, government is treated as one decision-making unit so that politics of decision-making and administrative divergence do not dilute from the responsibility which the government owes as a political unit to the legislature. This year, Lordship brings together the entire ladder which I was saying. This is crucial to ensuring that government is responsible to the aspirations of the people in whom political sovereignty resides. This is an extremely important, actually, I read the other paragraph, this leads up to this, the heart of it. And then when it's 345, the doctrine of aid and advice enhances the commitment to the same democratic values which form the basis of collective responsibility. The mandate that a titular head of the government must act on the aid and advice of the Council of Ministers ensures that form of democratic governance is, that is decision-making in the name of a titular head, is subservient to its substance, which mandates that the real authority to take decisions must reside in the elected arm of the government. The real authority to take decisions must reside in the elected arm of the government. The doctrine of aid and advice enhances accountability and responsive government. Besides representative government, by ensuring that the real authority to take decisions resides in the Council of Ministers, which owes ultimate responsibility to the people through a legislature to whom the Council is responsible. Collective responsibility in the aid and advice doctrine must not be considered as disjunctive. I would very strongly, for my purposes, underline this. But together constitute integral parts of discourse in ensuring the strength and commitment to democracy. Because all of it is important, but 344 and 345, 343 and 345 are the heart of the matter. Just see one para of Justice Mishra in this connection. Chief Justice Mishra, as he then was, at page 4770.
Chief.
Yes.
Para 208 in the same judgment
Page.
of Chief Justice Mishra's judgment. 4770,
PDF 477.
internal page 624.
Dr. Singhvi, I think the content of para F relating to the nature of the executive power is also very important.
My apologies,
You
because I
skip
may have
that.
missed it in trying to.
Because that's how the link forms, no? Because ultimately we are talking about exercise of executive power.
Your Lordship is referring to which parameters?
The page 679, F, nature of executive power. In that you can just.
679 of the SCC.
SCC.
Yes.
Your
just read away.
continuous page 4825. Because it gets linked to the executive power.
675 is it?
679,
Yeah,
para
I just-
346 onwards.
Yes, please. I've got it.
348 you can actually read,
Yes.
page 4826.
It is not already touched with that arrow.
Go on
Scrolling
page,
takes time.
go on PDF page.
348.
Para.
May I read 348 please? Before elucidating the nature and ambit of the relationship between the Council of Ministers and the Lieutenant Governor, the Lieutenant Governor and the President, it will be necessary to advert to some of the other provisions of 239AA which have a bearing on these relationships. The Lieutenant Governor, as we have noted earlier, is appointed by the Minister.
No, the executive, how the executive power works.
Is appointed by the President under 239(1), read with 239AA1. The Chief Minister appointed by the President, while the other ministers are appointed by the President on the advice of the Chief Minister. They hold office during the pleasure of the President. The concept of collective responsibility of the Council to the Assembly is expressly embodied in Clause 6, which I read to your Lordships. Comparative analysis of the provision of the Constitution relating to the Council of Ministers in the Union and of the States indicates that in case of NCT, 239AA is engrafted, the fundamental precept of collective responsibility of an elected government in a cabinet form of government to the elected legislature, creating an executive power in government which is coextensive with the legislative power of the elected legislature and the collective responsibility of the Council of Ministers to the legislature are intrinsic to the cabinet form of government. Whereas my apologies, I should have read this myself. But this is
357, 4830. So it is connected now. It is connected to the exercise of the executive power.
Then, my Lordship,
The collective-
352,
Three-
para Lordship said?
357.
48307.
357, yes.
Para.
I've got that. Just give me a second, Melissa. These provisions of the Constitution institutionalize the relation between the President and the Union Cabinet and reaffirm the position of the President as the titular head. The President,
Parliament, the Central Council,
yes, but
not the state.
no, Melissa, with respect. My Lord is citing all of them in a state 239 AA case. My Lord is adapting it for the 239 AA case and minus the excluded powers. The Westminster model with collective responsibility is fully adopted. It's fully adopted. I learned when we argue that to the contrary, well, it is not at all limited to just the presidential form of. These provisions of the Constitution institutionalize the relationship between the President and the Union Cabinet and reaffirm the position of the President as titular head. The President must act on the aid and advice tendered by the Cabinet. The executive power of the Union is co-extensive with the legislative power of Parliament. In a cabinet form of government, it is the Council of Ministers which owes collective responsibility to the House of People. Collective responsibility as a constitutional doctrine ensures accountability to the sovereign will of the people who elect the members of the legislature. This is very, very important. Though all executive action is expressed to be taken in the name of the President, and the orders and instruments made and executed in the name of the President are authenticated in the manner prescribed by the rules, the constitutional position of the President is of a titular head. The use of the expression the exercise of his functions in 74(1) is formalistic in nature, since the substance of executive power is vested in and conferred upon the government constituted through the Council of Ministers, which owes collective responsibility to Parliament. The proviso to 74 stipulates that while the President may require the Council to reconsider his advice, once that has been done, the President is bound to act on the advice tendered after reconsideration.
Dr. Singhvi,
Yes.
now if you can go to para 360,
360,
where we have tried to now bring the balance between the union territory.
Well,
To what extent does it adopt the cabinet form of government, and to what extent
my lords, well,
it
also-
sort of gives greater powers to the lieutenant
I'm
government?
grateful. Good one. Just
360,
spend half a minute on 358 also. The position of the President as a titular head of state is evidence that the constitutional provisions is defined.
That's the-
I'll leave that. Because on the state is not that state.
Let's go to 360.
Then 359 is governor and state, come to 360 minutes. While assessing the status of NCT, certain significant aspects need to be borne in mind. 239 AA is a result of exercise of constituent power under 368. By and as a result of 239 AA, special provisions have been made for the NCT. These are not an emanation of an act of ordinary legislation. For the NCT of Delhi, the exercise of the constituent power has resulted in a constitutionally entrenched status, both for the legislature and for the Council of Ministers. The Assembly is elected by the process of direct election. This is very, very important. The Assembly has the power to enact law in respect to matters in the state list of the 7th schedule. That is, save for 1, 2, and 18, and the other 3. Yet, while the Assembly, which has been conferred on the Executive Assembly to extend to state list, save for accepted entries, and the concurrent list, Parliament has been empowered to legislate both on matters falling within the state and the concurrent list. Parliament possesses overriding legislative powers over matters falling in both the state and concurrent list. This is a complete harmonization, I would say. Then, 239 AA4 provides constitutional status to the Council of Ministers and embodies the entrenched principle in a cabinet form of government that a titular head of state acts on the aid and advice tendered by his ministers, which owe collective responsibility to the state to the legislature. In setting up a structure of governance in which there is a legislature elected through the process of direct election and an executive arm which is collectively responsible to the legislature and which in the discharge of its functions tenders aid and advice to lieutenant governor on matters which are coextensive legislative power. The Constitution has incorporated the basic principles of the cabinet form of government. The adoption of these special features of the cabinet form of government in relation to NCT must weigh while interpreting 239AA.
Now 361.
Then
Yeah, the-
361. At the same time, constitutional scheme indicates several features in relation to the NCT, which have all resulted in the conferment of a constitutional status which falls short of the trappings of full statehood. They include the following. The position of the NCT is subsumed under Part 8, which applies to UTs. Delhi is and continues to be a UT. Every UT is under 239 administered by the President acting through an administrator. The administrator appointed under 239 is designated as the LG for the NCT. 239 is the source of constitutional power to appoint the LG for the NCT. The position that the application of 239 is not excluded in relation to NCT is made evident by 239AB. In a situation in which the President is empowered to suspend the provision of 239AA, where the administration of the NCT cannot be carried on in accordance with article or of any law made in pursuance of the article, the President is empowered to make consequential provisions for administering the territory in accordance with 239 as well as 239AA. Hence, the provision of 239A cannot be read disjunctive from 239(1). The administration of a union territory by Parliament acting through an administrator is firstly subject to parliamentary law and second to such extent as he thinks fit. Hence, the nature of the administration of a union, including NCT, is subject to these two provisions. The position of the NCT as distinguished with the constitutional position of a state finds expression in contrast between 239AB and 356. Upon the exercise of power under 356, the President can assume to himself the function of the government of the state and declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. In contrast, 239AB empowers the President to suspend the operation of 239AA or of any provision of law made under it and to thereupon make consequential provisions for the administration of the NCT in accordance with 239 and 239AA. While emphasizing the binding character of the aid and advice tendered to the President, or as the case may be the Governor, the constitutional position in relation to the LG contains a distinct variation. 74(1) embodies, in relation to the President of India, the binding character of the aid and advice tendered by the Council of Ministers by specifying that the President shall, in the exercise of his functions, act in accordance with advice. Upon the President requiring the Council to reconsider their advice, the President is bound to act upon the advice which is tendered. Similarly, in the case of governors, 163(1) provides for a Council of Ministers to aid and advise the governor in the exercise of his functions, except that the governor is required to act by the Constitution to exercise his functions in his discretion. 239AA4 incorporates in its substantive segment the constitutional principle of aid and advice which the Council of Ministers tenders to the LG. But in relation to the advice tendered by the LG, by the Council of Ministers, the proviso to 239AA4 has engrafted a special provision which does not have a corollary in 163. While under 163(1), the governor is required to act upon the aid and advice tendered, save in matters which the Constitution entrusts to the discretion. The proviso to 239AA4 contemplates an area where the binding character of the aid and advice tendered to the LG is lifted. So I'll just pause here. Till now, just give me 5 seconds. Till now, my Lord is saying it's the same as precedent, minus 3 excluded areas, 1 discretion, and 1 disagreement. 5 things. That's what my Lord is saying. That's the 5 special features of a UT under 239AA. Now let's come to 362. In resolving the area.
Comes up here, and your 3 principles are restated. The trinity of the 3 principles that you are mentioning in the commencement is restated here at 362.
Yes, that's 362. I'm grateful. That's why I paused there. Total is 5. Those principles now come together in 362. So your Lordship will not be, I'm saying the Lordship should not allow the incremental wrongful expansion of these 5 exceptions to make a UT into nothing more than a fiefdom of the central government. It's that simple. There's no doubt. This is state. This is UT Delhi minus 5. Nobody's cavilling at that. But now by incremental notifications, executive orders, directions, you can't increase those 5 to the universe. That's the short point. Now kindly see that, as my Lord Justice Narasimha puts it, 362. In resolving the area within which the LG can refer the difference of opinion with the Council of the NCT to the President, it would be necessary to balance on the one hand the constitutional principle of cabinet form, while on the other hand, leaving open the latitude which has been created by Proviso 4. You already have so much power as in Proviso. the former consideration would need the court to pursue a line of interpretation which does not detract from the fundamental principles of representative government. I'm very grateful, Manoj. This is what I was reading in the collective responsibility part. An elected government reflects in a democracy the aspirations of the people who vote to elect their representatives. The elected representatives carry the responsibility of giving expression to the political will of the electorate. In a democratic form of government, real power must subsist in the elected arms of the government. The ministers of government are elected representatives of the people. They are accountable to the people through their collective responsibility to the legislature. As a collective entity, the Council of Ministers owes responsibility to the legislature. The relationship between the Council of Ministers and the titular head is governed by the overarching consideration that real power and substantive accountability is vested in the elected representatives of the people. The principle of aid and advice is in a constitutional sense intended to strengthen the constitutional value of representative government and of governance which is accountable and responsive to the electorate. While bearing these fundamental constitutional principles of democracy in mind, a balance has to be struck with the second of the above elements, which recognizes the special status of NCT. The NCT represents, this is extremely important, the NCT represents the aspirations of the residents of its territory, but it embodies its character as a capital city, the political symbolism underlying national governance. The circumstances pertaining to the governance of NCT may have a direct and immediate impact upon the collective welfare of the nation. This is the rationale for the exclusion of the subjects of public order, police and land from the legislative power and necessarily from the executive power of NCT. These considerations will necessarily require a careful balance between the two principles. Each of the two principles must be given adequate weight in producing a result which promotes the basic constitutional values of participatory democracy, while at the same time preserving fundamental concerns in the secure governance of the nation.
I try to draw balance. The judgment. One, that the Article 239 AA and the 69th Amendment, which brought it about, preserves the basic principle of the cabinet form of government, collective responsibility, and aid and advice. These are the bedrock of representative democracy.
Parliamentary democracy.
Parliamentary democracy. And we have therefore said that 239 AA embodies that. At the same time, we said that this is really a constitutional scheme which is created for the governance of the National Capital Territory.
So by exceptions that
Which, in that sense, of course, is not merely a matter of the residents of that territory, but symbolizes the entire nation.
That's why
the nation in proper governance. And therefore, we said that on the other hand, that's the reason why three subjects have been carved out: public order, law and order, and land. Because that's something which really, in that sense, represents the national interest in the secure governance of the National Capital Territory. So you really need to balance both. You can't read one to the exclusion of the other. You need to bring a harmony between the two. Now, the question which we really have to confront is control over the public services. Does it exclusively lie in one? Does it exclusively lie in the other? Or is there a median?
Therefore, Manoj, let me just, what is implicit, but also not said explicitly just now, implicit.
The concern that there should be a representative government would warrant that control over the public service must exclusively vest with the Council of Ministers once the officers are allocated to the Union Territory. Because according to you, it is only through controlling your officers who are allocated to the Union Territory that you can implement legislation and policies. Otherwise, you'll be bereft over the control and And therefore, you will have no accountability to the legislature and the people.
More than that, I will have no governance tools to
But then
satisfy the
we
electorate.
also need to ask ourselves to at what point of time does control over the public services really go into the second realm, the latter realm of, a proper national governance, or does it go into the?
Therefore, may I, my lord, as well as that's the
area
issue.
which we need
With
to
great
respect.
respect, that's the issue. I bow down. Now, just note 2-3 sentences here. Willis. What is implicit in all this, fellows, if your lordship's paras, these paras, some places even explicit, that otherwise, why does your lordship start with the president and the Indian advice, central government? Your lordship starts those paras with that. Is that the Westminster parliamentary government has to have the titular head and the governing head. I'm not talking of NCT, just leave it aside. Then having described that as Westminster, as President, as Article 73, etc., your lordship turns to Delhi. It is because Delhi is a dual role of a national capital that not 3 but 5 exceptions, that delicate balance that the Honorable Chief Justice just now said, is struck by the text of 239AA itself in the first place. The delicate balance is struck A, by excluding 3, B, by giving something which your lordship doesn't have in the central government, namely reference on a disagreement, C, by giving a further power of acting in discretion, which is there in some governors, etc.
One way to harmonize
Third.
would be to say that control over the public services, insofar as it relates to the 3 excepted subjects, excluded subjects.
That is certainly one way, Mills. That is the correct
That will
way.
not vest with the.
Sorry for the
That will not
interruption.
vest
It
with the
is
Delhi government.
already, it's not their case also, they should get it. It's not their case also, number one. Number two, while earmarking, my lord, possibly, did not include 3 excluded categories explicitly and insofar as category.
That is totally your
Mills,
subject.
can I just...
Insofar as
can I
it's
just-
applicable.
Now, Mills, it comes back to the same notification. It comes back to 2 phrases. Insofar as, and Mills, there are only 2 services. It comes back to... Anyway, let me, Mills, not... My chain of thought is a little different. So first is presidential normal Westminster. Second is the 5 exceptions in NCT. Your lordship will note this. Third, all your lordship sayings about will of the people, electorate, the very rationale of giving a legislature to Delhi are negated if your lordship will not appreciate the reality as is being sought by the impugn notification to suggest to your lordships, that once any civil service is allocated to a state, and for present purposes, your lordship must hold the state to be equal to UT. Otherwise, there is no governance. Once it is allocated to a UT in this case, the power of appointing, transferring, appointing to post X or Y, disciplining, acting, terms of service of that person have to be with that UT.
Now, Dr.
Now,
Sikri,
fourth.
we've seen, yeah. But now, this is 2 areas which we need to wrap up.
Yes.
Before we conclude your submission.
Those rules.
One, the statutory rules govening these services,
Yes,
which
yes.
we'd like to see.
Yes.
And then finally, we would like to see what is the difference between Justice Sikri and we need to see that.
Justice?
Between Justice Sikri and Justice Bhushan in the 2-judge bench, because I mean that led to the 3-judge and then now
Yeah,
the
that's right.
Bhushan bench.
So, may I just, I'm
Because
saying
I think now the judgment we have covered.
this is covered. I'm ending this, just note 208 para of Justice Mishra, just one
Yes,
para,
we want to see
just
that.
for completeness.
Yes, yes.
I'll be going in that sequence, only excursions. Formalist federalism
page
for
is
just
that?
2 minutes, then I'm coming in that same.
What page is that?
PDF 4774. Mark 4770.
228, right?
208.
Or 208.
Show me that, show me. Seven zero निकाल दो. 770.
Yes, sir.
The legislature, the Legislative Assembly, Council of Ministers, and the Westminster Style Cabinet, brought by the 69th Amendment, highlight the uniqueness attributed to Delhi with the aim that the residents of Delhi have a larger say in how Delhi is to be governed. The real purpose behind the Constitution Amendment of 91, as we perceive it, is to establish a democratic setup and representative form of government, wherein the majority has a right to embody their opinion in laws and policies pertaining to NCT of Delhi, subject to the limitations imposed by the Constitution. For paving the way to realize this real purpose, it is necessary that we give a purposive interpretation. It's very, very important. This object of lordship has to be actually implemented in real life, not in an ivory towerish sense as the central government believes. It is necessary we give a purposive interpretation so that the principles of democracy and federalism, which are part of the basic structure, are reinforced in their truest sense. As I'm ending this section by a quick short reference to that book about civil service. Just 2 minutes. Now, this is bookmark 3-4. And why it's interesting is only because of the way he puts it. Just 3 portions take only 2 minutes. Well, this is a civilservice.org.uk by a former civil servant. The page is 2557. Understanding the civil service. I'll read a few lines here and there. And I'm not going to take more than 2 or 3 minutes in this. Civil servant, civil service numbers. Then let us come to the next page where he says civil servants, ministers and parliament. That is 2558. Civil servants work within a constitutional framework known as the Westminster model. May I read that, Lordship Gadat? 2558. Your Lordship is at bookmark 34.
2562 of PDF, right?
2562, 4 page. 2562 with the index count.
562. 2558 is the running number.
2558 is actually 2562 of your Lordship's PDF. It's 4 pages ahead.
What is this book about?
This is Manus civilservants.org.uk. It is a website, Manus, updated and maintained, and a very well-known and very eminent and popular website by a senior former civil servant in UK. On civil service meaning in the Westminster system, I literally take only a few lines from here and there. May I read? Justice Rasma has got it. Now, the civil servants, ministers and parliament. Civil servants work within a constitutional framework known as the Westminster model, which requires them to be politically impartial while being principally accountable only to ministers within the current government. This is a reality your Lordship knows. This is something basics have to be again underlined because this is not true in case the
2558.
civil servants, ministers and parliament. Civil servants work within a constitutional framework known as the Westminster model, which requires them to be politically impartial while being principally accountable only to ministers within the current government. What is the point of having the notification which will make them unaccountable to me? They also work within a wide range of ethical and other constraints which are taken very seriously by both senior staff and the wider public. This includes an ethical code which requires officials to be honest, impartial, challenging, collaborating. One of their key skills is to achieve their objectives while observing both the letter and the spirit of their various objectives.
Yes.
That's
2563, which is 2567, I think, in your lordships.
25, what is it?
2563, which is your lordship's 2567. PDF 2567.
yes.
Your lordship has seen the opening where he says this is the system.
One
and
minute.
structure. The culture of civil service is.
One minute.
My apologies, my apologies.
2567.
6-3.
2563.
Printed 63, continuous pagination is, I think, 67.
But that's why they are serial monogamous.
No, it's just a.
So long as the representation, so long as the relationship lasts, loyal to only one. Once the
That's the
relationship
meaning of a
changes, we
state
switch
frame,
loyalty.
because their loyalty is to be to the governance and the constitution. You kindly see this. I mean, it's just by, I'm ending on this point, it's only the last point of this. Then I come to federalism and then I come to the rules. The culture of the civil service is quite unlike that of other organizations in the UK.
You know, very beautifully put. 2567.
The culture, please read.
Yes.
The culture of the civil service is quite unlike that of the other organization in the UK. Civil servants are expected to be highly professional, serial monogamists, intensely loyal to their current ministers. This is important because there is no loyalty where there is no control to even transfer. There is no serial monogamy, Manas. There is consistent monogamy with somebody else outside the room, but ready to switch allegiance whenever there is a change of government. And they are simultaneously expected to respect the vital role of parliament. The relationship between civil servants, minister and parliament was highly respected and emulated to a certain or greater lesser extent in many other countries. It still has its admirers and nonetheless has many critics who argue it is outdated. I'll leave this first. Then just see 2565, 2 pages. Above, under 1.2 minutes, para is 1.2.
UK Constitution.
Just above 1.2.1. Legitimacy and democracy. May I read that? Page 2565.
Yes.
Just above para 1.2.1. 2 paras above that.
Yes.
Legitimacy and democracy are maintained because ministers are answerable to Parliament and the House of Commons is elected by the people, subject to complying with the laws made by Parliament. Day-to-day decisions are taken by ministers and if necessary by the whole cabinet and implemented by a politically neutral civil service. Put shortly, there is a simple change of command. Accountable to ministers, civil servants accountable to ministers, ministers accountable to Parliament, members of Parliament accountable to the constituents, and so on. Now, one more thing was 2569, para 1.3. 2569, para 1.3. The lengthy Armstrong Memorandum, first published in 85, summarizes the duties and responsibilities of civil servants. Most important parts are, civil servants are servants of the Crown. For all practical purposes, the Crown in this context means it is represented by the government of the day. The civil service as such has no constitutional personality or responsibility separate from the duly constituted government of the day, which has to be the NCT government. You are alter egos of the government, not of some other master outside. It is there to provide the government of the day with advice on the formulation of the policies of the government, to assist in carrying out the decisions of the government, and to manage and deliver the service for which the government is responsible. The civil service serves the government of the day as a whole, that is to say, Her Majesty's ministries collectively, and the Prime Minister is the Minister for the Civil Service. The duty of the individual civil servant is first and foremost to the Minister of the Crown, who is in charge of the department in which she or he is serving. Each minister is responsible to Parliament for the conduct of his department and for the actions carried out by his department in pursuit of government policies or in discharge of responsibilities laid upon him as a minister. A minister is accountable to Parliament in the sense that he has a duty to explain in Parliament the exercise of his powers and duties and to give an account to Parliament of what is done by him as in his capacity as a minister or by his department. Civil servants are responsible to their ministers for their actions and conduct. The British Civil Service is a non-political and professional career service subject to a code of rules and ethics disciplines. Civil servants are required to serve the duly constituted government of the day of whatever political complexion and so on. Now, Manas, I turn very briefly to a few paras which we've left out on federalism, and then I'll come towards the federalism is important, Manas, because this whole thing is lying in the context of two shared sovereignties. This part is over. Westminster, collective responsibility, area and advice is over. Now your Lordship is broadly put the thing of federalism. Now my Lords will just note the points and then I'll read a few. Lordship is capturing the essence. But my submission is one. But incidentally, it's very interesting. I once Googled the Constitution, and one of the largest constitutions of the world. It has federal or federalism several times. but not a single word federalism as we understand it, from preamble to the end. All those references to federal are to the federal court. So, Malats, it's the only concept which your lordship did not enact in the preamble,
Yes.
did not put in the text of the entire constitution, but is held to be a basic structure. It's a very interesting, Malats, and a rightful paradox. I mean, I entirely support it. Federalism should be and is a basic structure, at least, of course, since Bommai. But it doesn't find a text in the preamble onwards. And your lordship immediately finds hundreds of federal coming, that's for the federal court. No federal otherwise. Now, Malats, federalism is vital because it is telling you how to share sovereignties. National is first, but regional is no less important. Regional, local, state level. It is this dual manifestation. There are, as I said yesterday, Manas, there are multiple manifestations down to municipality and your lordship's panchayat chapter part now. But we are not going there. It is this dual manifestation which, Manas, is the heart of democratic will. Because all democratic will can't be centered on one sovereignty. That's point number 3. Point number 4. In that sense, Manas, we the people create 2 governments at least, as I said, multiple. Central government and state and union territory governments. So this manifestation is a dual or a triple manifestation of the popular will exemplified by we the people. The 4th aspect or the 5th aspect under this head, Manas, is that there is no more important concept than federalism in a diversity context. Actually, people talk of federalism even in Western countries. In Germany is an example. England is the opposite example. But that federalism is nothing compared to the diversity we have here. There are homogeneous people, language, style, habit, religion also. With the diversities we have in this country, federalism is the most self-preservatory basic structure your lordship has found. It is actually more of self-preservation. Your lordships cannot have a country like India except by a very, very real, in-spirit federalism practice. 5thly, Manas, the priorities, the purposes, and the philosophies. This is not intended, there is some alliteration there. Priorities, purposes, and philosophies of these 2 or 3 sovereignties which manifest through federalism are not only bound to be different, they are intended to be different. That is the true meaning of how federalism accommodates these different priorities, different purposes, different philosophies. The union territory government may have a different priority in terms of policy bills. Give ABCD and focus more on that priority and less on X, Y, Z. And the central government is equally entitled to focus more on priority X, Y, and Z. One more on welfare, one more on infra. One where so many ways, I don't itemize. You manage these differences of priorities, of purposes and philosophies because you say that federalism will deal with the concept of multiple sovereignties, giving enough space in your house to you without interference. Federalism is nothing else but a very, very nice constitutional concept of live and let live in the political and the governance sense. And live and let live in a real sense, not live and let live in a formal sense. Now let's just turn to para 51 to 56 of my Lord Justice Chandrachud's judgment in that matter. This is the same, no? I'm sorry. This is called a judgment called Mohit Minerals, which is relatively recent.
CV2.
And it is, what is the bookmark number? Oh, I see.
2-1.
We filed it in the convenience volume 2, Malas, the second one. Bookmark, yes, bookmark.
We give the citation.
Bookmark 1, the first case, and it is at page 74 of the second volume.
Citation.
Citation, yes, citation. Sorry, apologies. Scrolling takes some time.
Bookmark 74 or page 74?
Bookmark 1, page 74 is the relevant portion.
Got it.
Whereas 2022,
Very first case.
10 SCC 700, decided by a 3-judge bench was headed by my lords on 19th May 2022.
This is Union of India versus Mohit Mandals.
That is, where is it, Dr. Singhi? I can.
Volume 2, very
The
first.
second
Oh,
volume,
volume 2. All right.
Very first case.
Yes.
Relevant para. Mr. Sanghvi,
and your lordships would well turn to
which at the relevant para?
51 at PDF page 74 and SCC page 773. Your PDF page may be 4 pages ahead. but-
Yeah, 70. Para? He is referring to para.
This is all NCT issues, 239 AA issues. Underlying it, the heart of it is federalism. May I read this?
Yes.
Murari has got it.
Which paragraph here?
Para is 51
51.
at page 1 is PDF 78 and SCC 773.
Yes, 78. Yes.
The
Well-
dual, I'm reading this. The dual federalism model or the autonomy model views the constituting units of the center and states as autonomous, independent, and competing units. This model is also termed as competitive federalism, where the constituent units compete with each other. Proponents of the cooperative federalism model argue it is a mistake to view each unit as a separate autonomous entity. According to the theory of cooperative federalism, integration and not autonomy is the objective that federalism seeks to achieve. Integration and not autonomy is the objective that federalism seeks to achieve. While dual federalism is termed as layer cake federalism due to the delineation of structures of power, cooperative federalism is known as marble cake federalism due to the integrated approach of the federal units. In NCT, the court has observed that India follows a model of cooperative federalism, where the union and state governments need to iron out differences that arise in the course of the path of development. Chief Justice Mishra said this. Thus, the idea behind the concept of collaborative federalism and negotiation is negotiation and coordination, so as to iron out differences which may arise between the union and the state governments in their respective pursuits of development. The union government and the state government should endeavor to address the common problems with the intention to arrive at a solution by showing statesmanship, combined action, and sincere cooperation. In collaborative federalism, the union and state government should express their readiness to achieve the common objective and work together for achieving it. In a functional constitution, the authority should exhibit sincere concern to avoid any conflict. Provision as to the source of authority, we are absolutely unequivocal that both the center and the states must work within their spheres and not think of any encroachment. But in the context of exercise of authority within their spheres, there should be perception of mature statesmanship, so the constitutionally bestowed responsibilities are shared by them. Such an approach requires continuous and seamless interaction. The Indian Constitution has sometimes been described as a quasi-federal, a constitution with a centralizing drift. Because when the constitution is read as a whole, the union is granted a larger share of power. Instances of this centralization drift can be traced to Articles 254. However, there are instances of 246A where the center and the states are conferred equal power, merely because a few provisions of the Constitution provide, a few provisions of the Constitution provide the union with a greater share of power. The provisions in which the federal units are envisaged to possess equal power cannot be construed in favor of the union. The union and the states have a simultaneous power to legislate on GST. GST Council has the power to make recommendations, etc. I'll skip this first. 53. The federal system is a means to accommodate the needs of a pluralistic society to function in a democratic manner. This is very important. Pluralism and democracy. Representative government. It attempts to reconcile the desire of unity and commonality along with the desire for diversity and autonomy. Democracy and federalism are interdependent on each other for their survival, such that federalism would only be stable in well-functioning democracies. Additionally, the constituent units in a federal polity check the exercise of power of one another to prevent one group from exercising dominant power. The Indian Constitution, though necessarily federal, does confer the Union with a higher share of power in certain situations to prevent chaos and provide security. And that's what the Constituent Assembly said also. However, even if the federal units are not entirely autonomous, as in the traditional federal system, the units still wield the power. The relationship between two constant units that are not autonomous but rely on each other for their functioning is not in practice always collaborative or cooperative. If the states have been conferred lesser power, they can still resist the mandates of the union by using different forms of political contestation as permitted by constitutional design. Such contestation furthers both the principle of federalism and democracy. When the federal units are vested with unequal power, the collaboration between them is not necessarily cooperative. Harmonized decision thrives not just in cooperation but also on contestation. Indian federalism is a dialogue in which states at the center constantly engage in conversations. Such dialogues can be placed on two ends of the spectrum: collaborative discussions that cooperative federalism fosters at one end and interstitial contestation at the other. Then, Your Lordship quotes on interstitial as uncooperative federalism. That's rather interesting. They argue that the states which possess lesser power could use licensed dissent by using regulatory gaps or by civil decision, etc. Can I skip that and come to 55? Such form of contestation, as the authors term it, uncooperative federalism, is valuable since it is desirable to have some level of friction, some amount of state contestation, some deliberation generating froth in our democratic system. Therefore, fellows, don't think that because there is power at one level, at the other level, the power is any less democratic. Therefore, the states can use various forms of contestation if they disagree with the decision of the center. Such forms of contestation are also within the framework of Indian federalism. The GST is not merely a constitutional body restricted to the indirect tax system, but an important focal point to foster federalism. One of the important features of Indian federalism is fiscal federalism. This, fellows, is one of the 6 tendencies which my lords have generally, not your lordship judicially, but experts, academics have said, inadvertent or unintended federalism. What in 2022 your lordship is in India is far, far more federal than when India started in 1947 or 1950. One of them is fiscal federalism, where your lordship devolves 43 to 45% of all the funds and grants to the, and money is where the shoe pinches or the shoe. So money is important. It used to be 30% when we started. And that is, fellows, in the context of GST, I'll not read it. But, fellows, may I end on federalism by saying, there cannot be, fellows, a teleological purposive interpretation of 239AA. A teleological purposive interpretation, which my Lord Justice Mishra has already said in that paragraph, without factoring in the genuine, legitimate spirit of federalism as an equal sovereignty with the constitutional limitations put there. So, now, Malaz, I turn to a couple of shorter points and then I'll come to those rules. One is, Malaz, NDMC, just note, I don't even need to read it. It is bookmark 38, open it. It's bookmark 38 in the second volume. This one which your lordship is handling.
2100.
Yeah, don't need to go to it. Let me just point out first. Citation is 1997, 7 SCC 339. Please note 2 things. 1. The issue is important. What was the issue, Manas? May I formulate in 2 lines because that will make it shorter. Your Lordship may want to note it down. The issue was squarely and admittedly this: whether municipal taxes imposed under the NDMC Act, whether municipal taxes imposed under the NDMC Act, on state government properties in Delhi, in NDMC area, amounts to union taxation and is therefore exempt under 289 of the Indian Constitution. I repeat, it is important one. Whether municipal taxes imposed under the NDMC Act on state government properties in Delhi, falling in the NDMC area, some 40 odd kilometers, is union taxation and therefore exempt under 289. The majority simply held very simple thing, Manas. Yes, exempt if non-commercial state property. No, not exempt if commercial property. That is the entire. Second point, in sequence. Second, NDMC had nothing to do with the functioning of the Delhi Assembly or the NCT government vis-a-vis the central government. Nothing. Thirdly, your Lordships has noted the scope of NDMC in the judgment itself. In the second one. Convenience volume first. Huh? Para Manas. Just give me a minute. Don't have it. Open it, please. Well, it is on your page 4765, internal page 619 of the Constitution Bench of NCT. May I read para 195?
1 minute.
Which volume?
The original NCT Constitution Bench Lordship is using.
Volume 1.
Volume one.
One.
Volume one.
Lord is using this.
Poor vault one.
102. NDMC matter.
No.
NDMC 7S.
No, not NDMC. I am on NDMC as dealt with by a Lordship's Constitution Bench. So the Constitution Bench deals with it in para 195.
Page.
At page 4765 of the first convenience volume of Lordship is using. Internal
475.
6.
It could be 4769. TF 4769.
Para 195.
195. But please keep in mind the issue I gave you, Lordships, and the finding of NDMC. In that light, read this. So, well, Chief Justice Mishra says this. Now, let us allude to the post-69th amendment. The other part is ready. 9-judge bench in NDMC, wherein Justice Reddy, speaking for the majority, after taking note of the rivalized submissions pertaining to union taxation, we call him Aman quickly, you can't play around this. Referred to in Sea Customs Act, said this. In the year 91, the Constitution did provide for a legislature for the Union Territory by the 69th Amendment. But even here, the legislature so created not a full-fledged legislature, nor did it have the effect of assuming that it could lift the NCT by Delhi from UT category to the category of states. All this necessarily Then after that, he goes on to say at para 155, quote 155 of the NDMC. It is necessary to remember that all the UTs are not situated alike. There are certain UTs, Andaman, etc., for which there can be no legislator at all as of today. There is a second category of UTs covered by 239A, which applied to Himachal, Manipur, Tripura, Goa, Daman, Diu, Puducherry. Now, of course, only Pondicherry serves in this category, the rest having acquired statehood, which have legislatures by courtesy of Parliament. Parliament can, by law, provide for constitution of legislatures for these states and confer upon these legislatures such powers as it thinks appropriate. Parliament had created legislatures for these UTs under the Government of Union Territories Act of 63, empowering them to make laws with respect to matters 3 and 3, but subject to its overriding power. Third category is Delhi. It had no legislatures with effect till 1956 until one was created and introduced by 239AA. We have already dealt with the special features of 239AA and need not repeat it. Indeed, a reference to 239B, read with clause 8 of 239AA, shows how the UT of Delhi is in a class by itself, certainly not a state within the meaning of 246. In some, it is also territory governed by Article Clause 4. Thus, MDMC makes it clear as crystal that all UTs under our constitutional scheme are not on the same pedestal. As far as NCT Delhi is concerned, it is not a state in the meaning of 246. Though NCT of Delhi partakes a unique position for the 69th Amendment, yet in sum and substance it remains a UT, which is governed by 246 and to which Parliament in the exercise has given the appellation of NCT. That's all. Now your Lordship will go to my Lord Justice Chandrachud's judgment, which is at the main, the bigger page number, 4877. I need my notes after this here. It's straight up. Okay. At 451 is the para number. The page is 4877. The PDF page may be 4881. Where my Lord starts with this topic.
Para 450.
451. The decision in NDMC is the title. I'll just include after.
Come back after. Roughly how long now, Dr. Singh?
Well, I'll be for in half an hour, 40 minutes.
Between Dr. Singhvi and the solicitors, we'd like to wrap up this matter by tomorrow evening because the bench is sitting only for this week. So between the two of you, please make sure that the matter is wrapped up by tomorrow.
Very good.
Today you finish by half an hour, within half an hour.
I'll try.
Which means that Dr. Singhvi, you can't bat for 4.5 days. Huh? And tell the Solicitor General that now I'm putting you into bat for half a day.
Yeah, 4.5 days. The Lord should arrest him. My learned friend Malus, who's been very ably assisting me, wanted 5 minutes at the end of it. I'll give him that 5 minutes so that he leave one point for him to cover and the Lord should not spend a bunch of the time.
Actually, the solicitor would really have to now argue as a matter of first impression because cases and all we have read, they can pinpoint, whatever.
The same cases are both, so we don't have to repeat that.
There's a lot of material which has not yet been faced.
But you convey that we'll finish it by tomorrow. Huh? We don't want to spill it over to next week. Now we are very serious on that.
They have to finish because bench is not available then.
It's a little short rejoinder of mine also, Manus, that your Lordship may fit in because.
By tomorrow, whatever you want.
Yes,
to do
that's what I'm saying. So, Manus, in our mutual fitting, we have to fit that small little thing also. Manus, 451, I'll be very quick. Manus, 4877. Let me not read everything.
Yes.
4877. And in your Lordship's judgment, para 451. A 9-judge bench in NDMC dealt with whether properties are exempt. And I'm doing some speed reading. Your Lordship will leave that. That's the issue which I told your Lordships. Whether properties owned by a state are exempt under 289. Then 452. So your Lordship has dealt with it. Therefore, your Lordship's judgment stands in the context of NDMC. 452. Justice Reddy spoke for the majority of 5 judges. The minority view of 4 judges rendered by Chief Justice Ahmadi. The judgment of the majority notes that the states put together do not exhaust the territory of India. Parliament has the power to make laws with respect to any matter for any part of territory of India not included in a state. Since the UT are not included in the territory of the state, Parliament was the only lawmaking body dealing with the provisions of 239AA. The court held. So this is the 239AA part.
And
Can I skip this by reading the last 5 lines?
Yes,
that is enough.
Above all, the union territories are
With your Lordship's permission. D, below D, Manus. Once the union territory is a part of the union and not part of any state, it follows that any tax levied by its legislative body is union taxation. Admittedly, it cannot be called state taxation. Under the constitutional scheme, there is no third kind of taxation. Either it is union or state. This may be true of taxation, Manus. It is not true in the context in which your Lordship is dealing with the subject. Taxation may certainly be true. I mean, your Lordship does not have a union territory taxation.
All right. What's the next point?
So 453 is important. Your Lordship, having said this, put this caveat. Actually, it's 453 which is the most important from my perspective. The judgment of the majority also holds that all union territories are not situated alike. The first category consists of UTs which are no legislature at all. Second category are legislatures created by law enacted by Parliament under the Government of Union Territories Act. The third category is Delhi, which has special features under AA. Though the UT is in a class by itself, it is certainly not a state in the meaning of 246 or Part 6. Nobody is claiming it to me. I'm always claiming myself to be a UT only. Then, Malus, your Lordships comes to the rules. Now, this, Malus, in view of your Lordship's time constraint, please come to para 41 of my written submissions. It really shortened it because it's dealt with their category. And I'll show some of the rules as we go along, very briefly. Para 41, which is at page 32 of my submissions. Page 32 of my submission. Civil servants from all India services and central government services who serve, one thing I must clarify. All that I'm seeking, actually, I cannot imagine a more minimalistic issue. All that I'm seeking in this case is, this is important before I read this section.
Yes.
All that I'm seeking is that civil servants, once they are there serving in the UT of Delhi, where to post them? In Department X or Ministry Y?
Yes.
All that is involved is a very simple thing. Once a civil servant is posted in NCT, working in NCT, A, where department, where ministry to post him, B, when and how to transfer him, and C, related obviously, is which work to allocate to him, which work not to allocate to him. And D, will also wants to add, reporting to which minister. Now, I am not seeking disciplinary power, that is not the case. Over them, whatever are their own rules will govern. Well, I hope my lord is.
Yes.
Normal rules govern the civil service, they will govern. Disciplinary power may be in the Ministry of Personnel, etc. I'm not concerned with that. I am saying that you cannot prevent me and should not prevent me for good governance from posting to a post, giving the nature of work and transfer. Intra-state, intra-NCT. That's the only case. And well, in that, you also keep in mind the joint cadre.
Para 41 now, so that will sort of summarize.
Straight away. Before that, one sentence. What am I arguing about? Only posting to a particular allocation of work and transferring within the state. Please keep that in mind. That I submit is unacceptable. Your disciplinary rules can have anything. You can go to the President of India, you can go to the central government, don't care. One more sentence, please. Joint cadre means that it's an all India cadre, but the posting is in a state or a UT. And the UT will then decide intra-cadre how to allocate you. That's the only issue. Now read 41 onwards. Government civil servants from the All India services and central government services who serve in the government of NCT are under administrative control of the government of NCT in respect of postings and transfers. Does my lord have it?
Yes.
Insofar as All India services and the personnel of central government services who serve in the government of NCT are concerned, the position and respect of control over them will be governed by the statutory rules framed in respect by the government of India as they apply to the NCT. It is submitted that the net result of these rules, as will be explained hereafter, is that while making a person available for services in NCT, you can make him available for Arunachal or Bihar or West Bengal is your choice. Once he's available to me, then what happens is the question now. Available services in NCT is the function of the joint cadre authority. This itself brings in the UT1. The actual posting of that officer to any department in the government of NCT is within the domain of the government of NCT. The above flows from the cadre rules of, just let us read through it, just mark it, I'll show them in a minute. We'll save your official time rather than jumping each time into the rule. It is clear from the 1954 rules and the 1972 rules, that is the joint cadre and the IAS cadre. The function of the joint cadre authority under the All India Services joint cadre rules is under 5.1 to determine the names of the members of the All India Services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their service shall be available. Now, unless you say in the same breath that states here means no UT, which you have said just now you don't mean, then UT has to be covered because services are there in the UT also. If you read it literally and state means only state, no UT, well, that would be a ridiculous situation, my humble and respectful submission. And they are disclaiming.
So we are restricting only to the posting and transfer.
My heading says that.
With respect to the officers who are allocated to the Delhi cadre.
The answer with the deepest respect is an emphatic yes. And I have taken care to put that in my heading. If your Lordship doesn't mind.
Right.
The heading above 41. And well, there is nothing else required because I am not supposed to go and say that in the cadre, this man cannot go to West Bengal. He must come to Delhi. Or your Lordships cannot have him serve in the Supreme Court on deputation, but he must come to me. That power I am not asserting.
The cadre controlling authority can say, well, we're pulling
And
this.
that itself is a joint cadre.
Sending him somewhere else.
I am grateful. That itself is a joint cadre controlling authority. It's a mix of everybody.
But
Well,
once
state-
it's a limited point that once you are here, then the government must have the authority.
Intra. I'm very grateful. That is important to narrow down. Now, let's kindly continue. It won't take long. 33. The joint cadre authority is established. This is important. Apropos, my Lord Chief Justice's comment just now. Joint cadre authority is established under Rule 4 of these rules, which constitutes a committee comprising of representatives of each of the governments. This is state autonomy and federalism. Under Rule 4 of the All India Services, joint cadre for Arunachal, Goa, Mizoram, UT. That is the AGMUT or the AGMUT. AGMUT. Established in 95, whereby Delhi along with Arunachal, Goa and Mizoram is represented in the joint cadre through its chief secretary. This is conclusive, I submit, brothers. That's true of every state of joint cadre. And that is the meaning of, otherwise states would start saying that we don't want an all India service. We want each state to have its own service. But just give me 30 seconds. This is important. If your lordships were to be persuaded to hold that you can't have this joint cadre and then you allocate to a state and he works it within the state himself, then state would say, why should you have an all India service? The all India service is appointed to me. He will work under the direction of the All India Master. He will be transferred as All India Master. What point of having? Then I'll have my own service.
Yes, Dr. Singh.
The IAS cadre rules of 54 define state to include UT. Further, mark this one. I'll be showing this rule to your lordships. State to include UT. So one is Chief Secretary of my UT sits on the joint cadre. Two is state includes UT. Further, state government concerned in relation to a joint cadre has been defined to mean joint cadre authority. As per IAS cadre rules of 54, once an officer is allocated to a UT, the mandate of posting falls within the jurisdiction of the state government concerned, which in this case is NCT. The two questions of my Lord Justice Chief Justice and Justice Judge now. Therefore, by virtue of having the authority to allocate the postings of officers, where and in what department those officers will serve, is also within the executive competence of NCT. Rules 2 minus just come straight away to 2 brackets C below. State means the state specified in the first schedule to the Constitution and includes a UT. State in relation to a joint cadre means the joint cadre authority. Postings, all appointments to cadre post shall be made in the case of a state cadre by the state government, in the case of a joint cadre by the state government concerned. I'm sorry, this is very, very important one, but doesn't mind. 7B. In the case of a joint cadre, let's say All India Service, the posting will be by the state government concerned. State government is already above, includes UT. No, already above, it includes UT. Now it will come in 11. 11A. Authority to exercise certain powers in respect to the members of the service, serving in connection with the affairs of the state's
Just
constitution.
1 second, Dr. Singhvi.
I beg.
Just 1 second.
Yes.
All appointments to cadre post shall be made B in the case of a joint cadre
No, state cadre first. By the joint cadre, by the state government concerned.
by the state government concerned. Now, state government concerned is defined up there.
To include the UT.
No. D. State government concerned in relation to a joint cadre means the joint cadre authority.
Yes, correct.
That means posting in the case of a joint cadre has to be by the
Joint cadre authority. In which fellows all the states are, UT. No, 11. In that joint cadre authority, my chief secretary, other states is sitting.
So they will post an officer to the
That joint cadre authority will say, now read 11A.
11A.
Now read 11A. It is represented on the joint cadre authority.
Right.
Now read 11. Authority to exercise certain powers in respect of members of the service, serving in connection with the affairs of the state constituting a joint cadre. This is the answer to my notes very directly. The powers of the state government under the second proviso to 4.2 and subrule 6.2 and 7, 10 and 11 in relation to the members of the service, serving in connection with the affairs of any of the constituent states shall be exercised by the government of that state. Well, it's with great respect.
Very clear.
Your lot unworkable. I mean, it is not very rocket science that this clause is put there. Suppose the lordship has a reverse clause. How does the lordship function? Make a system work, Manas? Today, Manas, this country has had single party governance for 50 years. Today, you have different party governance in different states. Tomorrow, you may have again single party for a while. Will these things change? You'll give states the autonomy to decide, Manas. You have to live and let live, Manas. You have to have, all these words are only lectures otherwise. Cooperative federalism, competitive federalism. The reality is, you give me an officer, I can't post him to Department X, I can't post him to Department Y, I can't allocate sewerage against water to him. It's as simple as that. As per Rule 2C of the IAS Cadre Rules, state means a state specified in the first schedule to the Constitution and includes the Union Territory. As per Rule 2D of the IAS Cadre Rules, state government concerned in relation to a joint cadre means the joint cadre authority. As per Rule 7, postings are all appointments to cadre posts shall be made in the case of joint cadre by the state government concerned. So, well, teleological conjunctive interpretation of these four things: 2D, 7, now come to 11. In respect of joint cadres, the powers of the state government under Rule 7 in relation to the members of the services coming in connection shall be exercised by the government of the constituent state. Therefore, the collective reading of 2, 7 and 11 I submit is crystal clear with great respect. Shows that in case of the actual postings within the government of the state shall be made by the government of the state and not the joint cadre. The complete scheme which becomes clear from the above is that while it is a joint cadre authority where Delhi has its own separate representative, which allocates officers of the adjunct or adjunct cadre to NCP, the post in which such officer is posted deputed is determined by the NCT. Consequently, within, kindly mark the word within, the government of NCT, the said officer has to be posted from one post to another. It is the government of NCT alone which has the powers and the service rules. This is in consequence with the position that prevails in the states of Arunachal, etc., which are also members of the joint cadre. Further, this is fully in consonance with the position of the civil style, the Westminster style. Similar, now we move from the Agmut to Danix and Danix. Similar is the position of the Danix and Danix. That as per the Danix rules, while it is the government defined under the rules as the government of India that allocates a member of the service, once that allocation is done, it is the administrator acting on the advice of the council who posts within the NCT. Posting. Every member of the service allocated to an administration shall, unless he is appointed to an ex-cadre post or is otherwise not available for holding a public service, be posted against a duty post under the administration by the administrator concerned. Allocation of, here it is, allocation of members. The government shall from time to time allocate a member of the service to any administration. Next paragraph. The scheme, obviously, the administrator has to act on aid and advice. That's the whole scheme. That the scheme that emerges from the above is that while it is the government of India that allocates an officer to an administration, it is the administrator acting on the aid and advice of the Council of Ministers in terms of 239AA, who posts the officers within the government of Delhi. There can be no doubt in these rules, the administrator has to act on aid and advice, because in terms of clause 4, it says, this is your lordship's own constitutional clause 4 on aid and advice. There shall be a council of ministers considered not more than 10%, with the chief minister at the head to aid and advise the lieutenant governor in the exercise of his functions, with the respect to which the assembly has, or any other law required to act in his discretion. Provisions such as the above have been interpreted to mean that the law must specifically and explicitly require the administrator to act in his discretion. Otherwise, he is required to act on the aid and advice. Well, this is very important. He has to act on the aid and advice. What is discretion is something very different. Appellate, review powers, revisional powers, special powers, special powers. Nawab Rabia said this, and even if your lordship were to review Nawab Rabia and the other matter I am appearing in, your lordship will not be reviewing this part. That is Malas on giving you a notice to a speaker, disabling you and then walking out. That's the point on which we are arguing the other matter. So this will remain good law, it's not on the challenge. Just by the way. We are therefore of the considered view that insofar as the exercise of discretionary power vested with the governor is concerned, the same is limited to situations where a constitutional provision expressly so provides that the governor should act in his own discretion. Unless it says so, or it will mean aid and advice, bound. Additionally, a governor can exercise his function in his own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of the respondents that the governor has the freedom to determine when and in which situation he would take a decision in his own discretion without the aid and advice of the Council of Ministers. We may therefore summarize our conclusions as 155.1. Firstly, the measure of discretionary power of the governor is limited to the scope postulated, therefore, under 163.1. Secondly, under 163.1, the discretionary power of the governor extends to situations where a constitutional provision expressly requires to act in his own discretion. Here it would be one of the you may have a parliamentary law which says expressly the administrator shall himself decide whether to appoint me to a minority. It may be. That's the express conclusions. In the light of this conclusion very quickly was A. Exclusion of entry 41 from the legislative executive can and absence of effective administrative control over those serving in would mean the collapse of the Westminster style of government and the principle of collective responsibility. It would completely negate the purpose of introduction of AA and would in fact defeat the amendment. Seventh schedule has been enacted under 246. Under 246, the term state has been held not to include territory, that is Kanyan. In the absence of the phrase, insofar as any such matter is applicable, all entries with the term state in list 2 and 3 would not have been available to the Legislative Assembly at all. Therefore, the term insofar as such matter is applicable is not a term of exclusion or restriction meant to exclude the availability of entries in list 2 or 3 of the 7th schedule, but is a phrase that facilitates the ipso facto availability of all the entries containing the word state in list 2 or list 3, and in this case, in the Assembly. The Balakrishna Committee to the extent it treats is incorrect. I'll leave Balakrishna Committee, please. Part 14, dealing with services, envisages services of a UT in addition to services of the union and the state. This has been held in Prem Kumar Jain. Bala report finding, which has been relied upon by the Union of India, that Part 14 does not envisage services, is therefore wrong. This is directly wrong. I'll skip it. One of the Lordship has made some observation about Bala. For the above reasons, the Constitution Bench rejected the use of the Bala report as an aid to interpretation. For an acceptance of the argument of the Government of India that entry 41 is not available to UTs and that UTs cannot have services of their own will require not just the overruling of the decision in Prem Kumar Jain, but also disbanding of joint cadres such as AGMUT by the Union of India, as also setting aside large number of provisions of the Jammu and Kashmir Reorganization Act. Malus, to not have a service at all has far-reaching repercussions, apart from federalism, apart from state administration, regional, etc. The actual experience of administration of the UT with the legislatures, namely Delhi and Jammu and Kashmir. Two examples with legislatures. Entry 41 is available to UTs with legislatures, and various enactments have been enacted by legislatures of UTs that contain provisions that directly relate to and derive power from entry 41. I've given you a list. Delhi minorities, Delhi Lokayukt, Delhi so-and-so, etc. Union territories can have their exclusive services and public service commissions. The payment of emoluments to all those serving in the government. Now, this Lordship asked me the question early on yesterday. Payment of everything, again emoluments, is part of my annual budget, passed by an appropriation bill of my assembly. It is unimaginable that the assembly or the government of Delhi that is responsible for raising revenue and making payments to those serving in NCT, but the answerability of those is elsewhere. L. Under the respective services, the transfer and posting of these to these services within a UT lies with the elected government. Within, that's L. M. While the above position prevails in the UTs with legislatures sufficient for the purpose of NCT or the present case, the position of NCT, given that the legislature are constitutionally mandated and not pursuant to a simple parliamentary law, necessitates effective control over the civil services. It is otherwise necessary to do any implementation of policy. Any implementation of policy is one of the nugatory without my control over my own civil service. It is just a chimera. It is just one of the pipe dream that anybody will listen to me. the exclusion of entry 41 would be contrary to the majority judgment. I have cited that, the Lordship is read it, etc. Well, it's 2 minutes more. Just note. Take an example where your Lordship has no power in NCT to appoint, transfer, allocate work. Take that. I'll give you 2 or 3 very quick, 1 minute example. Example 1, Malas. I am NCT. I decide that COVID needs me to appoint 100 staff in Delhi government's NCT's 5 hospitals in Delhi. Either I can't appoint, or I can appoint 5, or I can appoint 7. I then decide that this staff is better suited to Safdarjung Hospital or the other hospital which are mine. No, that transfer cannot be by me unless somebody else agrees. Example 2, I am paying suddenly in the middle, suppose for whatever reason there is some event happening. Payment of salaries is delayed, stopped. Payment towards rent and staff salaries for running primary health centers may be stopped. Primary health center run by NCT. No, you are running primary health centers, you have got 100 people, you should have only 20 people. I would pay the salary of the balance 80. Your Lordship gets a water treatment plan. For several months, the water treatment plan, which is a policy manifesto, stated that we are going to clean this place. Certain stretch in Yamuna apart, actually. Well, the bureaucrat concerned says that no, I have to answer to, I can't meet the ministers for this. Well, I am not going to any affidavit. These are hypothetical examples, but they are real examples, unfortunately. Sorry, I can't meet you. I've already written my report to the LG.
Either he relies upon or he does not rely upon.
Very well.
Because I have an answer.
Now, Manas,
They are
in the light of
factually
this,
incorrect.
I am
And
concluding.
as per the contemporaneous record, they are incorrect.
Either I am, anyway, let's leave that.
Don't say something and say that I'm not relying upon.
Either I am not living in Delhi or Mr. Mehta is not living in Delhi. Both of us can't be living in Delhi.
But we take it that
No, this-
what you
anyway.
are giving us are hypothetical illustrations of what may happen if we don't accept your argument. That's
Please
your
take it as hypothetical. What will happen definitely in case I have no power. Let me put it like that. Well, I'm done now is one thing. My learned friend will take by the clock a few minutes to make that point about other capitals and the fact that your Lordship actually has the strange irony that you have less power in the NCT than your Lordship gives to the municipality. And in the worst example of those capitals, the most centralized, least liberal example, the power of the state government is more than what has been conceded to the NCT. That's 2 minutes to make sense. Now, I want to end by saying, I'm concluding this. Please see the larger picture. Well, here is a person who's trying to save his burning house. That is me. I am not trying to go and attack his house. Where is the question of my encroaching upon 1, 2 and 18? I am trying to save what I've got. Number 2, if your Lordships were to be persuaded by this argument of competence of the NCT, as raised by the Government of India, it would amount to that I will be left only with areas of incompetence. I have left with nothing. If this is the understanding of a competence, then this elected government is left with incompetent areas only. Number 3, it is something like a gearbox system. The constitutional gearbox of this is those who implement the civil service. You are giving me a gearbox which I can't change. Either I drive in only gear number 1. I can't speed up the car. I can't go to gear 4. All the levers of the gear movement are in somebody else's hand. You give it to me that, look, I have given you a gearbox which is fixed at 1. Well, this system can't work. The car can't move. The people of Delhi cannot benefit. Also, if your Lordships were to have this and your Lordships in your experience as administrators also know that no civil servant will feel that he is answerable in any which way. All these long lectures we are giving about accountability to the minister, minister to the legislature, legislature to the people. He is simply not bothered. The practice of the matter is that you are bothered only about the person who can deal with you, who can transfer you, who can post you. In practice, all the homilies we give, civil servants are very smart people also. They know that I am not to be bothered unless I am answerable to you. Therefore, I beseech my lords that I am asking for a minimalist power, which normally nobody should need to ask for. It is implicit in the very creation of NCT. Otherwise, you should have no NCT. It is implicit in the creation of NCT as a constitutional legislature. What? I can post them, I can decide where to post them, I can allocate work, and I can transfer. That's all. I'm very deeply obliged.
Thank you, Dr. Singhvi. Yes, Mr. Farah, sir.
I just, the lots will permit take about 15 minutes, not more. Because just one
Now
main
that 2 minutes will become 15 minutes. I thought.
Because your lordship will grant me 15 minutes if possible. That I'll complete the points in that. I will not take more than 15 by that clock. I'll not take your lordship to any of the documents I intended to. I'll just place the point. The point is there in the written submissions. Plus the main point I want to address your lordship, and there's two subparts, is that what is the interest of central government in controlling the services of a union territory of Delhi? And my respectful submission is there is none. Because really speaking, what the central government is seeking in this matter is, it's a kind of argument of red herring. Plus my government's, the civil servant who's functioning in my government, his ability to function is limited by the competence of the government itself. Because whatever I can do in my constitutional competence, that is exactly what the civil servant can do. Because he can't go beyond that competence of the government. Your lordships will strike it down, the courts will strike it down. So, what is the real interest, if any at all? And my respectful submission is there is none of the central government in controlling day to day, the civil servants who are serving in the government of NCT of Delhi or denying the entry 41. Because in that respect, two aspects I want to place before your lordships. One is, what is the experience of global capitals across the world? Because there are three different, there is a 2009 book, your lordships will have the supplementary written submissions which we have placed. Plus para 9 onwards. I'm not going to read, I'm just going to place the point. Well, there are three different kinds of capitals. There's a book of 2009, that's the latest book we could find on a comparison on federal capitals across the world, their governance structure. The learned SGS filed something from 1970. Plus, what does that say? Well, there are three categories broadly. One category is where there is a federated district. The capital is a federated district of the union. District, I use the term in a loose sense. It is the federated territory of the union. In that, for instance, there will be Abuja in Nigeria, Addis Ababa in Ethiopia, the African states are there. There are certain Washington DC in the US will also fall.
What is the paradigm there that the capital is a
federal district? That is, it's a federal district.
Like Washington DC.
Yeah.
Like DC. And I've given 5 other examples. That is category 1. Within that category also, there is a huge play of things in each of those categories. I'll come to that in a moment. Plus category 2 is where the capital is a completely federated unit. That is an independent federated unit, and that's the capital. Berlin for Germany and Brussels in the case of Belgium. The third category of lordships is where the capital is in the province of a full-fledged state. The capital city is in the province of a full-fledged state. So if Delhi were in Uttar Pradesh, if Delhi were
capital is in the
province of a state.
Is that in the province of
a state? Ottawa, in Canada is in the province of Ontario. And if there is a fourth category, really South Africa, it doesn't formally have a capital. Well, all the South African constitution says the parliament will be in Johannesburg. There's no formal capital. The executive government is in Pretoria. And the constitutional court is, the constitutional court is in Johannesburg. The parliament is in Cape Town and the executive government is in Pretoria. There's no formal capital. But if we look at the divergence of administrative structures in all of them, there are three things which stand out. One is the area of competence given to the local government. Second is there a legislative override? That is, a central legislature overrides the local legislature. Third is there an executive override? Does the central executive override the local executive? There's a range of combinations. So, at the most federated level is something like Berlin, which is very high degree of competence. The width of the competence area is broad. No legislative override, no executive override. And the other end of the spectrum is very narrow competence. Legislative override, executive override. But in none of them, and that's important for our case, None of them. The services in the local government are sought to be controlled by the center. None of them across the board, irrespective of the combination of these three factors, that within the area of competence, the federal government seeks to say, I will control your officers. It just doesn't happen. Then, my lords, there is an example of London. My lords, as your lordship is aware, London, my lords, is the most centralized democracy, not just possibly in the Western world, but in the world. Similar to Article 39AA, in 1999, they enacted a Greater London Authority Act 1999. They established a Greater London Authority. That, my lords, established a directly elected assembly, 25 members of the assembly, and a mayor. Because there have been 3 mayors in London till now: Ken Livingstone, Boris Johnson, who then became the Prime Minister, and presently is a gentleman called Sadiq Khan. But interestingly, it's a little similar. When Boris Johnson was the mayor, the Labour government was in power in the centre. And today Sadiq Khan is from Labour and the Tories are in power. So, but there, Section 67 and 70, you lordships will just make a note, it's there in my written submission. The power to appoint the staff, to set their conditions of service, everything is with the authority. Why should us have a central government have any interest in that? And this is not even a federated system. The first line was the examples I gave of federated systems. UK is not even a federation. Their House of Lords is not like our Rajya Sabha, which represents state interests. The House of Lords is a bunch of peers which are appointed to a certain process, but there's no federal interest. Even in a country where there's no federal interest, the management of the capital at a local level, there's no interest of the central government in controlling the services of that. And finally, I will come to our own Delhi Municipal Corporation Act, and that I'd like to just place the sections. The MCD Act, which has been enacted by the Parliament, plus para 16 of my supplementary written submissions, which your lordships will have. Plus section 89 and 90 of the MCD Act give the power to appoint. Well, section 89 is for important posts. Your lordships will just make a note of it. For important certain designated posts, the power is with the corporation itself. That is with the elected arm. Corporation is the elected arm. Under section 89, the power is with the corporation itself.
Yes.
To appoint certain important people to certain important posts. Under section 90, the standing committee, which is the elected sub-body of the corporation, approves different posts. Under section 90, they approve different posts for the corporation, and in pursuance of that approval, then the commissioner makes the actual appointment. So there is complete elected arm control under the MCD Act. Well, surely a parliamentary form of democracy with a Westminster style system with federalism in play, we can't be worse off than the Municipal Corporation of Delhi.
So the power to appoint is again there, not given to the center, but.
That's right. And Mullah, insofar as any concern, I possibly cannot see any concern of the union in the day-to-day administration of the government of Delhi. And your lordships will test this, because all matters of federalism which has come before this court are in the context of 2 different political parties. That's been the jurisprudence in the 70s. Before that, it was one party rule. We didn't even have cases before this court. Because your lordships will give a construction which will bear the weight of competing priorities by 2 different political parties.
Anything else, Mr. Farasar?
So, Malas, finally, if there is a concern, if at all, once services come in the remit, if there is at all a concern, plus that can be taken care of by Article 239AA4 proviso, the power of reference. So your lordships have already held that in cases of extreme importance, the matter can be referred to the president and the president's decision is binding. The same will apply in case of services. So we are not in a position to damage any interest of the union. Like Dr. Singhvi said, we are just protecting our house. It's already circumscribed for us, but can we even function within our house? So I'll just conclude my submission with that that your lordships will grant us entry 41, both as a for the purpose of legislation and executive, and the power to transfer and post officials who may belong to central service who, as per their own rules, we are entitled to. And because there is no concern of the central government in interfering in day-to-day affairs of ours. Because I'm extremely grateful for that.
No, 1 minute. What do you mean by legislative power with respect to entry? Because it's a cadre post, correct? The services are allocated to the Delhi government, correct?
Yes.
Where is the question of legislature? What to be legislated?
So, my lords, that impugn notification does.
Because so far as the education qualification, everything, mode of appointment, you can't have. Then what type of legislative power you want?
So, my lords, may I attempt to answer?
Yeah.
My lords, the impugn notification does two things. It says I don't have entry 41 available to in my legislature. It does that first. So, my lords, we need that even for creating a post. Because your lordship is right. Certain posts, the top post will always be cadre post. In a principal secretary in a department will be a cadre post, will be an all India service person. And that's why we showed to your lordship those rules, that even vis-a-vis him, we have the power to post within. But for everything else, for creating posts, if I'm creating a hospital, a health service, I need to create posts for that. Can my legislature pass that act? It can. And I need entry 41 for that. What does the impugn notification say? I can't, because I don't have entry 41.
But tell us something in the Delhi government hospitals, for instance.
Yes, ma'am.
You already have Delhi government hospitals. You have Delhi government schools. What about the ministerial posts? Like who has legislated, who sanctions the post, who appoints?
Well, so post 2015, we have been earlier, Malats, there was what the way it used to happen was the ministers concerned would do it, and the matter will go up to the LG in the normal mechanism as a matter of communication. Now what happens? We have no play. The situation is so bad that the Speaker of the Assembly cannot even appoint a secretary in his own office.
Actually, factual assertions may be confined to.
I'm responding to a question from the court.
The factual assertion we confine to.
No, but for instance, in your just as a matter of clarification, in any Delhi government hospital, you would have n number of posts. Who has sanctioned those posts in the past? They were sanctioned by the Delhi government.
So, Malaj, there is a certain level of what has happened is there is a certain level of ossification in time which has happened post 2015. I am not in a position to create more posts. Whatever had been already done. Now it's the LG doing it his. If at all we request him, if it's created, if it is not created, all of that is happening. But whatever was there pre-2015 is continuing.
Let me very quick to ask a direct question. After all, 239 AA has been there from 1992. There have been at least 3 governments or 4 governments of NCT between that time and now. So, well, it's not the law has changed. Let's be very frank. Well, the law has not changed. The harmony of working has changed, which is why do you have litigation? Why do you not?
Always.
Today, what your lordship is asking is, the correct answer is this, that the posts were created long ago. Please look at the last 2-3 years. Any post is created, transferred, appointed, can't be. Because how long can we keep on arguing on letters that the actual bus will be gone, the person will be dead, the patient will not be required, COVID will be gone. We can't argue on these things. So it needs clarity only from a Supreme Court. Otherwise, we can keep on having.
To say, my relative may not say that.
No, but I have to say something. I can't speak here, We are not living in the Antariksh. We are living in Delhi.
Thank you.
Grateful to context.
Thank you, Mr. Farah.
Grateful to you.
Wait, please, Your Lordship. My lord, I'll change the chronology which I decided I'll, my lord, assist your lordship in, my lord. But in view of, my lord, the last rhetorics which were, my lord, more fiction than facts, my lord, let me abuse, my lord, any impression which is created. Lord, your lordships are aware, my lord, the capital of any country always has a sui generis position. Lord, I am completely in agreement, my lord, with my learned friend that it is an elected government. The collective responsibility principle must not only be implemented, must be respected. Elected representatives are answerable to the people, and that democratic polity must, my lord, in the most harmonious manner, Lord, discharged by both the stakeholders, namely the central government and the state government. Lord, the impression, Lord, I must, Lord, point out, Lord, what we are dealing with, what essentially your lordships are dealing with, is a matter of perception and not a matter of constitutional law. The perception which is created, not only inside the court, but very recently and in past also outside the court, that there is no power because LG is supreme, LG does everything, we are just symbolic, we do nothing, we can do nothing without the permission or sanction of the LG and the officers owe allegiance elsewhere. Elsewhere, my learned friend was very, very decent in not defining elsewhere. I'll put it central government. That's the position. Your lordships are dealing with a mechanism, a structure, constitutional structure which came into existence in 1992. After 1992, several governments came in the central government and several governments came in the state. There were several occasions where both the governments were belonging to different political ideologies. But I'll rely upon my Lord Justice Chandrachud's one para, where my lords have been pleased to say how that balance is to be maintained. And that one crucial word was with political maturity. And so far, Lord, these questions have never arisen. And everything had been going on, my Lord, smoothly with harmony. Even today, and I'm going to, my Lord, disabuse that impression which is created, my Lord, the law as in place, which is being effected, which is not shown to your lordships, my Lord, ensures that everything goes without any friction, unlike the popular perception built, my Lord, that only LG has the power and elected body is meaningless. It is the elected body which is in the seat of driving. And what is the, my Lord, role of the LG? Lord, that I would like, my Lord, your lordships to first see. Before I say, your lordships have seen Article 239 AA sub-Article 4.
But when you see that the elected body is in the driving seat, then what are the powers according to which the elected body will?
I'm answering that only. I'm precisely answering that. Lord, your lordships have seen Article 239 AA sub-Article 4, which says that in case of any difference between the elected wing, I'll put it colloquially, elected wing and LG, the matter will be referred to the President. Correct, my lords? Your lordships, my lord, in 2018 say that any matter can be referred does not mean every matter can be referred. Correct, my lords? I have gathered the information and your lordships would be shocked after this rhetoric. Right from 1992 till date, only 7 matters are referred by the LG to the President, registering the difference of opinion. Only 7, 92 till date.
So you want to say that except these the 7 which are referred, no difference is?
No, and total 18,000 files came as per law, as per 239 AA. And I will show the scheme, my lord. It's not, my lord, my learned friend completely skipped the GNCTD Act, which is passed in exercise of powers under 239 AA 7. And I will show, my lord, that scheme. Total, my lord, right from 2017, after your lordship's order, but constitution bench order till date, 18,000 files came to LG as per law laid down, and all files cleared. But let us see, my lord, the perception which is being built. And, my lord, how, my lord, the Honorable Chief Justice's query, how the Delhi government functions as an administrative unit, as a unit of governance, how Delhi government functions. Is it correct that it is the LG who runs the government, or, as your lordships have noticed and as has been going on since earlier 92 onwards, it is the elected body which is in power? Lord, kindly see, my lord, 239 AA C, the AA 7.
Who transfers? The question, earlier question was that who creates the post? Who decides the number of?
Can I come
That
to
is
a
what,
little later, my
No,
lord?
that is what the first question of Honorable Chief Justice was this. Correct? Who creates the post?
My lord, the central government creates the posts.
All posts are created.
Yes, my lord, and I'll substantiate that. That's the law.
Don't just.
Yes, factually, yes.
Factually, we
I'm
want
sorry,
to-
Lord. I thought, yes. Lord, the central-
Running is a different thing, and creating and posting and everything, that is transferring everything is a, that is what.
That also, my lord, they can do with, my lord, LG never refuses. If LG refuses, my lord, then it's a different scene. But I'll come to that, but let me go chronologically to point out what are the statutory provisions. That's, my lord, my purpose. Lord, kindly. Lord, kindly come to 239 AA 7. This, my lord, I must place, my lord. I will place, my lord, whatever is not placed for your lordship's consideration. But first, my lord, I wanted to go in a different chronology, but I thought, my lord, I must, because, my lord, as a constitutional court, my lord, the questions which are raised, the last part especially, would obviously weigh and should weigh. And it's my duty, my lord, to disabuse that impression. That impression is a castle in the air, my lord. I'll have to demolish that castle and say that this is the fiction and these are the facts. Lord, please come to, my lord, 239 AA 7. Lord, kindly bear in, Lord, when your lordships are at the constitution, Lord, please bear one thing in mind. 239. And I'll show, Lord, your lordships have said in the constitution bench, 239A also applies to Delhi. Save as otherwise provided by Parliament by law, every union territory shall be administered by the President acting to such extent as he thinks fit, through an administrator to be appointed by him with such designation as he may specify. Lord, he is the representative of the President. Lord, first of all, LG is not just an officer, he is a constitutional functionary, and his position, my learned friend tried to compare with the governor, is not that equivalent to the governor, my lord. He represents the President. Two may not be relevant, my lord, for the present purpose for either one of us, my lord. Kindly see, my lord, 3A7, 239, 3A7. I am on a limited point, my lord. I'll take your lordships to the entire article thereafter, my lord. The Parliament may, by law, make provisions for giving effect to or supplementing the provisions contained in the foregoing clauses, and for all matters incidental or consequential thereto. Any such law as is referred to in subclause A shall not be deemed to be an amendment of this Constitution for the purpose of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. In exercise of this powers, the Parliament has made NDMC, Delhi National I'm sorry, GNCTA, Government of National Capital Territory of Delhi. So kindly see section 44. This is how constitutionally Delhi as a unit of governance is supposed to be governed. My lord, your lordships would find page 430 of volume 1. Convenience compilation, my lord, section 44.
Page number?
Lord, 430. So there is a history behind this. Each and every word under Article 239 AA chosen with a purpose, with an intention, and based on the historical background, which I'll have to, my lord, assist your lordships with, my lord, in a minimalistic manner. I'll not, my lord, take that journey, my lord, from pre-constitution era. Your lordships have page section 44. My lord, the Chief Justice. The President shall make rules for the allocation of business to the ministers insofar as it is business with respect to which the Lieutenant Governor is required to act on the aid and advice of his Council of Ministers, and for more convenient transaction of business with the ministers, including the procedure to be adopted in case of a difference of opinion between Lieutenant Governor and the Council of Ministers or a minister, save as otherwise provided in this Act, all executive action of the Lieutenant Governor, whether taken on the advice of his ministers or otherwise, shall be expressed to be taken in the name of the Lieutenant Governor. Orders and other instruments made and executed in the name of the Lieutenant Governor shall be authenticated in such manner as may be specified in rules to be made by the Lieutenant Governor, and the validity of an order or instrument which is so authenticated shall not be called in question on ground that it is not an order or instrument so and so. We are not concerned. Lord, in exercise of this power, Lord, the President of India has framed transaction of business rules, which, my lord, I would earnestly urge your lordships to go through with me, my lord, and examine how the Delhi administration as a unit of governance functions. The powers are with the ministries, powers are with the ministers, the powers are with the Council of Ministers. Please see, my lord, kindly come to volume 3, my lord, page 16. And my lord, this would be crucial, my lord, for satisfying our lordship's conscience.
Page, what page, Mr. Solicitor?
Page 16, volume 3, PDF page 18. Look, this would be crucial to satisfy your lordship's conscience that everything is done by LG and ministers are just sitting and whiling away their time. They can do nothing. I'll my lord, for that purpose, my lord, I'm just pointing it. I'll come to my lord services a little later and other legal submissions. Lord, this kindly see the title, in exercise of the powers conferred by section 44 of the Government of National Capital Territory of Delhi, President hereby makes the following rules further to amend the transaction of business rules of Government of NCT of Delhi. So kindly see, B is Lieutenant Governor, C is capital, G is government, secretary means secretary of the department to the Government of the National Capital Territory of Delhi, and includes secretary to the Lieutenant Governor. Kindly come to 3. Lord, bear one fact in mind and I'll substantiate. And this is going to be, Lord, crucial to satisfy your lordship. Lord, how would your lordship decide whether the secretaries are acting as per the legal directions of the ministers or not? What is the test? The test is annual confidential reports, ACRs. For all secretaries who are heading each department, rest as down below. They are the subordinates of the secretaries. Is the secretary who, my lord, according to my learned friend, takes instructions from somewhere. My lord, the person who, my lord, kindly listen to this, my lord, a little carefully, who writes the ACR, the reviewing authority, is the Honorable Chief Minister. And I have last 3 years ACR of all officers heading the departments, out of 10, 9, 9.5, out of 10, 9, 9.5. I'll show that. My lord, kindly now, my lord, see what is the role of those secretaries vis-a-vis the ministers who represent the will of the people. My lord, 3. All contracts in connection with the administration of the capital shall be expressed to be made by the President and shall be executed on behalf of the President. Well, this is the significance of the Delhi not only as a union territory, but as a capital of the nation. Anything happening in Delhi not only has an impact within the country, but global. That's one of the purpose of UT. Then 3. An order or instrument made or executed in the name of Lieutenant Governor shall be authenticated by the officers empowered under the rules made by the Lieutenant Governor. Your Lordship may skip. Kindly come to Chapter 3. Disposal of business allocated amongst the ministers. 4. The council shall be collectively responsible for all the execution orders issued by the department of GNCTD, department, in the name of the Lieutenant Governor and contracts made in the name of the President in connection with the administration of the capital, whether such orders are or contracts are authorized by any individual minister in respect of a matter pertaining to the department under his charge, or as a result of discussions at a meeting of the council. The decision is taken by the minister either individually or in the council. 2. Without prejudice to the provisions of Sub-Rule 1, the minister in charge of a department shall be primarily responsible for the disposal of business pertaining to that department. LG nowhere comes into the picture. Please see note 5. Until the rules are framed or modified in this regard by the Lieutenant Governor under the Government of So-and-so Act, GNCTD Act, the rules and orders made by the central government, well, last 4 lines may be relevant, my lord. Subject to modification that reference to government in the state rules. Your lordships can skip that. 2. Unless the proposal is fully covered by the power to sanction expenditure or to appropriate or reappropriate funds conferred by any general or special orders made by the finance department in accordance with the rules. The finance department, my lord, comprising of the elected body, the finance minister, who owes his, my lord, responsibility to the council. Finance department in advance with the rules and orders referred to in Sub-Rule 1 above, no department shall, without the previous concurrence of the finance department, issue any order which may not involve financial transactions, more than this, etc. But I am not going into it. 3. No proposal which requires previous concurrence of finance department under this rule, but with which the finance department has not concurred, may be again proceeded with unless a decision to the effect has been taken by the council. I'm sorry, my lord, if I'm...
No, yes.
So again, my lord, the power given to the Council of Ministers. Then 4, no reappropriation shall be made by any department other than the finance department, except in accordance with such general delegation of power of reappropriation as the finance department may make. Then, my lord, 6. Lord, that again is financial transactions, but within the framework of the GNCTD of Delhi, the government infrastructure, there is an inbuilt mechanism which gives powers to the minister concerned. That's the limited point. Lord, 6A. And my lord, kindly, my lord, read this in a broader sense. Right now, my lord, don't read this, my lord, that's my request. From the point of view of who makes appointments, my lord. There is, my lord, something more than that. Lord, the attempt is not, my lord, to get appointments, power, etc., transfer powers, etc. Whenever they have requested LG, my lord, as per the rules, they transfer this man from here and there. There is no difference, my lord, that they can always approach LG and LG does it. There is no difficulty. 6A, but the attempt is something else, and that's where I'm trying to drive it. Yes, my lord, kindly read 6. The chief secretary shall be the secretary to the council. My lord, your chief secretary CR are written by the honorable chief minister, and he gets 9 or 9.5 since last 3 years, my lord, by the honorable chief minister. And the principal secretary, general administration department, shall be the joint secretary to the council. When the secretary to the council is absent, the joint secretary shall perform. Then 6A, the secretary of the department concerned shall be generally responsible .
Yes.
And unless your lordship knows, my lord, how the system functions, my lord, my lord, I would be doing injustice to the brief.
Yes,
my lord,
yes.
Persuading your lordships to give the correct meaning of 239AA.
Yes.
Lord, 6A, the secretary of the department concerned shall be generally responsible for preparing and authenticating every memorandum for consideration of the council and for obtaining approval of the minister in charge and the chief minister. There is a responsibility fixed under the rules made by the president that you will have to inform the council and the minister concerned. Then, my lord, 2, the views of both the secretaries and the ministers of all departments consulted on the proposal shall be clearly and separately reflected in the memorandum so as to ensure that in case of disagreement, the council shall take the decision. They cannot, officers can't take decisions from elsewhere. They will have to write in the notes why they are agreeing or not agreeing with the decision. And ultimately, the dispute is resolved by the Council of Ministers, not by any outsider. Then fourth, this is not very crucial. In case the secretary, and this is crucial because it's a capital of the country. In case the secretary to the council is of the opinion that the proposal considered and decided by the council is not in accordance with the provisions of law in force in the capital and rules of procedure, it shall be the duty of the secretary to the council to bring it to the notice of the lieutenant governor. So that lieutenant governor can take a call, and how he takes a call, there are specific provisions. He can't just receive the complaint and defer it and refer it. He can't do that. And this is not under challenge. Kindly see 7. Subject to the orders of the chief minister, if your lordships can, subject to the orders of the chief minister under Rule 8, all proposals referred to in the schedule shall be placed before the council in accordance with the provisions contained in this chapter. It is the Honorable Chief Minister who decides which proposals are to be placed before the council and which proposals would be decided at the ministry level, provided that no proposal in regard to which the concurrence of the finance department is required under Rule 5 shall, save in exceptional circumstances and under the directions of the chief minister, be discussed by the council unless the finance minister has had an opportunity of considering it. But one of the factors was flagged. I am not going into the facts because my learned friend has not gone into the facts. This was flagged, involving few hundred crores. I leave it at that. I am not going into that. All proposals referred to in the schedule shall be submitted to the chief minister after consideration by the minister in charge with a view to obtaining his orders, that is the order of Honorable Chief Minister, for the circulation of the proposal under Rule 9 or for placing it for consideration of the council. Then 9, the chief minister may direct that any proposal submitted to him under Rule 8 may, instead of being placed for discussion in a meeting of the council, be circulated to the ministers for opinion. And if all the ministers are unanimous and the chief minister is of the opinion that the discussion in a meeting of the council is not required, proposal shall be treated as finally approved by the council. In case ministers are not unanimous, or if the chief minister is of the opinion that discussion in a meeting is required, the proposal shall be discussed in a meeting of the council. If it is decided to circulate any proposal, the department to which it belongs shall prepare a memorandum setting out in brief the facts of the proposal, the points for decision, and the recommendation of the minister in charge, and forward copies thereof to the secretary to the council, that is the chief secretary, who shall arrange to circulate the same amongst the ministers and simultaneously send a copy thereof to the lieutenant governor. So that he can examine, he can apply his mind and decide whether to defer or whether to request and how to proceed. That also is provided for. How would the LG react? It can't be a knee-jerk reaction. 10. While directing that a proposal shall be circulated, Chief Minister may also direct if the matter be of urgent nature that ministers shall communicate their opinion to the secretary to the council by a particular date, which shall be specified in the memorandum referred to in Rule 9. If any minister fails to communicate his opinion to the secretary to the council by the date so specified in the memorandum, it shall be assumed that he had accepted the recommendations contained therein. If the minister has accepted the recommendation contained in the memorandum, please see, the minister accepts, or the date by which he was required to communicate his opinion has expired, the secretary of the council shall submit the proposal to the chief minister. Again, my lord, Council of Ministers, collective responsibility, will of the people. If the chief minister accepts the recommendation and if he has no observation to make, he shall return the proposal with his orders thereon to the secretary to the council, that is the chief secretary, for implementation. Then 5. On receipt of the proposal, the secretary to the council shall communicate the decision to the lieutenant governor and pass on the proposal to the secretary concerned, who shall thereafter take necessary steps to obtain the opinion of the Lieutenant Governor in case the proposal or matter is specified under Rule 23. I'm sorry, am I getting my lord?
No, I saw that, yes.
23, and I'll show my lord 23 are my lord issues of national concern. Then my lord 11. My lord 11, your lordships can skip 12. In the proposals which relate to more than one department, the minister shall consult other minister concerned in arriving at an agreement. If an agreement is reached, the memorandum referred to in Rule 9 or Rule 11 shall contain the joint recommendation of the ministers, and if no agreement is reached, the memorandum shall state the points of difference and the recommendation of each of the ministers. The council shall meet, my lord, at so-and-so place, etc., my lord. Then your lordships can skip that. Kindly come to 14, my lords, where again, my lord, the role of LG comes. The decision of the council relating to each proposal shall be separately recorded and after approval by the chief minister or the minister presiding shall be placed with the record of the proposal. After approval by the chief minister or the minister presiding, the decision of the council as approved shall be forwarded by the secretary to the council to the Lieutenant Governor. The chief secretary will send it so that he exercises his constitutional power, whether to refer or defer. Then where a proposal has been approved by the council and the approved record of the decision has been communicated to the Lieutenant Governor, the minister concerned shall take necessary action to give effect to that decision. The decision is to be implemented by the minister only. And we have not received a single complaint that some officer is not implementing the decisions though taken. We are the cadre controlling authority. We can departmentally prosecute.
As per this provision, only an intimation to the lieutenant.
Yes, so that he can decide his.
Not his concurrence or approval.
Except in case of 23.
Correct.
Yes, my lord. Kindly, my lord, read further. Lord, this is a castle which is built in the air. Therefore, I started by saying we are dealing with a perception created. We are not dealing with a real issue on hand. And I have not, nothing can be a better proof of saying that only in 7 cases, right from 92 till date, there is a defer and refer order. Defer with the decision of the government and refer it to the President of India. But being the capital of the country, the President's representative, namely the Lieutenant Governor, who is under Article 239 and 239 AA, entitled to be there, as your lordships have said, as a watchdog, is there, my lord, which is necessary. We are dealing with the capital of the country, my lord. And people of, my lord, residents of Delhi have not only reposed faith in the government of the GNCTD, my lord, ultimately the cadre controlling, my lord, kindly mark this, cadre controlling authority is not, my lord, some stranger or an alien. They are also, my lord, people's chosen representative. The capital belongs to the nation. Capital essentially belongs to the nation, and the national government, my lord, kind of keeps its, my lord, state by way of a separate constitutional mechanism. If there would be a Lieutenant Governor, you have truncated powers, Lieutenant Governor would have truncated powers, and this is how the scheme would function. And the scheme has functioned since 1992 in a very, very harmonious way. Now, my lord, further. Where a proposal has been, my lord, kindly 7, my lord, subparagraph, provided that before taking executive action in the proposal or matter as specified under Rule 23, the opinion of the Lieutenant Governor shall be obtained. My lord, here it is the prior opinion, not, my lord, subsequent opinion. Otherwise, my lord, it goes for opinion subsequently. My lord, then departmental disposal of business. My lord, kindly come to 15. Except as otherwise provided by or under these rules, proposals or matters may be disposed of by or under the authority of the minister in charge, who may, by means of standing orders, give such directions as he thinks fit for the disposal of proposals or matters in his department. The minister can say that my department would run like this. These are my standing orders. And if there is any breach, he can immediately inform the cadre controlling authority or the LG that Mr. X has not followed the directive which I have lawfully issued in exercise of these powers. Then 16 is important. Minister shall, by means of standing orders, arrange with the secretary of the department what matters or class of matters are to be brought to his personal notice. Minister can direct the secretary that this you bring to my personal notice. Don't do anything departmentally. Copies of such standing orders shall be forwarded to the Lieutenant Governor and the Chief Minister. I don't see there is anything prejudicial to this one. Then 17, every Monday, on next Monday, then that is meeting of the Council of Ministers, we are not right now concerned. 19, a secretary may call for and see the papers in any department other than the finance department or the appointments department if such papers are required for the disposal of any proposal or matter in his department. Each department head, the Secretary of Health, Secretary of Public Works, Secretary of Environment, etc., etc. A requisition, kindly see, a requisition made under sub-rule 1 shall be dealt with under the general or special order of minister in charge. Minister may call for papers from any department from his information. Please mark this one. A Minister of Health can call for papers from Minister of Finance, from the Ministry of Public Works. But there is a mechanism provided. Provided further that no paper under disposal shall be forwarded to any minister until it has been seen by minister in charge. If I am minister in charge of health, and if the finance minister wants to see my papers, my secretary will have to show it to me. That this is the requisition which has come. Should I show it to him? Power rests with the minister, the elected representative. Then, my lord, 4, the chief secretary may, this is, my lord, very important and crucial, the chief secretary may, on the order of the chief minister or any minister or of his own motion, call for and see the papers relating to any proposal or matter in any department, and such requisition by him shall be complied with by the secretary to the department concerned. Overriding power given to the Honorable Chief Minister. Other ministers need, my lord, approval of his colleague, the minister in charge, but the Chief Minister can call for any file. 5. Lieutenant Governor may call for papers relating to any proposal or matter of any department, and the secretary to the department concerned shall, within a period of 3 working days, comply such requisition, and he shall also inform the minister in charge of the department of the compliance of such requisition. He cannot do it behind the back of his minister. The LG who represents the president has a power to say that I want to see this file. The secretary will inform the concerned minister and comply with that, my lord. Nothing prejudicial, my lord. He is representative of the president in the government which runs the capital of the country. Then 20. If at any stage it becomes difficult to determine to which department the proposal or matter belongs, the subject matter shall be referred to the decision of the chief secretary, who will, if deemed necessary, obtain orders from the chief minister. Again, my lord, internal administrative authority of the chief minister. All communications received from the central government, including those from the prime minister and other ministers of the central government, other than those of a routine or unimportant character, shall, as soon as possible after their receipt, be submitted by the secretary to the minister in charge.
We got your point. As far as these business rules are concerned, they are complete code. Correct? Entire process. 1 minute.
I'm okay.
The powers are given to the concerned department, concerned ministers, the Council of Ministers, except the subjects which are falling under Rule 23. Correct? The decisions taken by the council, concerned minister or the Council of Ministers is final. Correct? And only intimation is to be given. So you proceed further. We got your point.
Can I, my lord, only request your lordships to
You read Rule 23 and then proceed further. We got your point actually.
Can I only, my lord, seek indulgence of permission to read 2 or 3 other, my lord, rules?
But which are the specific provisions in regard to services? Because, you know, these are transactional business rules covers the entire gamut of governmental business. Which are the specific provisions in
These are
regard
all
to
with respect
services?
to other businesses. That is why,
Kindly.
correct?
Lord, can I, my lord, the lordship may allow me, my lord, a little indulgence, my lord. And my lord, only, my lord, last few, my lord, page 20.
No, you were not there. We told Mr. Jain.
I know.
That you will.
I'm
No.
against time.
That is, no, against the time. You have got only 20 overs. You play whatever you want to write, but you have to play.
A test match. My lord, my learned friend played a test match. Not that, my lord, I will have to, my lord.
No, not that, but normally 20 hours, unless there is a tie. Okay.
No, ultimately,
we are eating your time. You can continue.
No, only three more provisions, my lord, which will, my lord, affect the question on the question of services also. My lord. I am saying, if there is any proposal for the purpose of my lord, appointment, LG would never oppose, and there is a system. My lord, kindly, my lord, allow me. I am using my discretion, my lord, that this would be relevant.
We are just pointing out that we have got your point. That is what we are informing.
Next, my lord, I'm on.
Okay, you continue.
But Mehta, therefore, are you suggesting that once an officer has been allocated to the NCT, then the LG not the way of the posting, the
posting,
transfer.
etc. Yes, I'll show that. I'll show the provisions. There are separate rules, constitutional rules. I'm not just disabusing the Lord, the Lord impression which is created. Lord, kindly, Lord, for that purpose, allow me, Lord.
And read Rule 23. What are the subjects which are exclusive?
45 also. 45 also. I'll read, Lord, first Rule 23. And 45 mechanism would satisfy my Lord's conscience. Lord. That's the purpose I'm Lord. 23. Lord, following classes of proposals or matters shall be essentially submitted to the Lieutenant Governor for his opinion through the Chief Secretary and the Chief Minister before issuing order. Where start, not after. Matters which affect or are likely to affect the peace and tranquility of the capital. Matters which affect or are likely to affect the interest of any minority community, scheduled caste and backward classes. Matters which affect the relation of the government with any state government, the Supreme Court of India, or the High Court of Delhi. Proposals or matters required to be referred to the central government under the Act or under Chapter 6. Matters pertaining to the Lieutenant Governor's Secretariat and personnel, establishment and other matters relating to his office. Matters on which Lieutenant Governor is required to make order under any law or instrument in force. Matters specified under general or special. Matters specified under general or special order issued by the Lieutenant Governor under proviso to Subrule 2, subsection 2. Petitions for mercy from persons other under under sentence for death and other important cases in which it is proposed to recommend any revision of a judicial sentence. Matter relating to summoning, prorogation and dissolution of the Legislative Assembly, removal of disqualification of voters at elections to the Assembly, local self-government, any other proposals, etc. Now kindly directly come to my Lord, chapter, and this is the last chapter, my Lord, I will be bringing to my Lord's notice, my Lord, page 28, chapter Roman 4, disposal of business relating to Lieutenant Governor's executive functions. So this would be crucial, my Lord, when I argue something, my Lord, tomorrow also. Therefore, my Lord, I want to bear this in.
28 running page or the
28, my Lord.
Just running page.
PDF page 30. PDF page is
28 is PDF.
Right.
There are, Rule 45. The Lieutenant Governor may, by standing orders in writing, regulate the transaction and disposal of business relating to his executive functions. He doesn't decide for others. Others is, my lord, these rules decide, this transaction of business rules. Provided that the standing order shall be consistent with the provisions of this chapter, chapter 5, and the instructions issued by the central government from time to time. Provided further that the Lieutenant Governor shall, in respect of matters connected with public order, police and land, exercise his executive functions to the extent delegated to him by the President in consultation with Chief Minister, if it is so provided under any order issued by the President under Article 239, provided further that standing order shall not be inconsistent. So, kindly, my lord, 46(2) directly. Notwithstanding anything contained in Sub-Rule 1, the Lieutenant Governor shall consult the Union.
1 minute, provided for the level of serving this.
I'm sorry, the particular service. Service is not your lordships were asking me. 46, my lord, your lordships have?
No, I was on 45 proviso, which you read.
That deals with his executive powers in regard to the three excepted.
3 excepts on 1 to 18.
Yes, yes. Insofar as, my lord, I'll come to that. For others, my lord, because there are specific exclusions, express exclusions, my lord, I would say, and implied exclusions, my lord. That, my lord Justice, my lord, the Chief Justice of India in CB has also, my lord, analyzed that. 46. With respect to persons serving in connection with the administration of National Capital Territory, the Lieutenant Governor shall exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service made under Article 309, I'll show, by the President of India. There are statutory rules made by the President under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President in consultation with the Chief Minister. Is similar. If it is so provided under any order issued by the President under Article 239 of the Constitution. 2. Notwithstanding anything contained in Sub-Rule 1, the Lieutenant Governor shall consult Union Public Service Commission on all matters on which the Commission is required to be consulted under Clause 3 of Article 320, and in every such case he shall not make any order otherwise held in accordance with the advice of the Union Public Service Commission, unless authorized to do so by the central government. All the respondents, all correspondence with UPSC and the central government regarding recruitment and of service of persons serving in connection with the administration of National Capital Territory shall be conducted by the Chief Secretary or the Secretary of the Department concerned under direction of the Lieutenant Governor. I'll show, my lord, the rules framed whereby the appointments are made by the Union Public Service Commission, and there, my lord, only LG is, my lord, concerned, and this provision is not under challenge. Under the guise of, my lord, interpreting services and Public Service Commission, my lord, this is what is nullified. I'd also show some of the statutory provisions, my lord, which, my lord, which are not challenged. Kindly see. 47. The matter in respect of which no specific provision has been made in these rules, the Lieutenant Governor shall consult the central government before exercising his powers or discharging his functions. The Lieutenant Governor, please mark this 47A is, my lord, salutary provision. And, my lord, this is how, as your lordships, my lord, the Chief Justice of India said in the CD, the harmonious working of, my lord, the two governments. This is how that harmony is incorporated. The Lieutenant Governor, after receipt of the proposal or matter under Rule 23, shall record his views on the proposal or matter within a period not exceeding 15 working days for legislative proposal and 7 working days for executive or administrative matter from the date of receipt of submission of such proposal or matter as the case may be. The Secretary to the department concerned shall place all relevant papers or information on record. Now please see 49. In case, this is salutary, I'm not earlier, but this is salutary. In case of difference of opinion between Lieutenant Governor and the Minister in regard to any matter, the Lieutenant Governor shall, within a period of 15 working days, endeavor by discussion on the matter to settle any point on which such difference of opinion has arisen, and if the difference of opinion persists, the Lieutenant Governor may direct that the matter be referred to the Council, elected Council of Ministers, which shall consider the matter and communicate its decision within a period of 10 working days from the date of the receipt, provided that in case the difference is not settled with the minister or the decision of the council is not communicated within the said period, it shall be deemed that the difference of opinion persists and the Lieutenant Governor may proceed further in accordance with provisions of Rule 50. In case of difference of opinion between the Lieutenant
Governor, but suppose after referring the matter back to the council, again council retest the decision, then what?
If there is different persists, then there would be a reference. It's not, my lord, that it's not like, my lord, president or the governor. That second time, if it is reiterated.
So just
yes.
on reading this.
Reiteration is not binding. Like president or the, for example, my lord, he is not the governor. He has a special constitution.
Okay.
Lord, if it is referred back by the Council of Ministers in a state, governor is thereafter bound. He can refer it once. Here, my lord, we will refer it to the president. That we could not sort out.
Mr. Solicitor, Rule 46 is the only rule which deals with persons which are serving in connection with the administration of the NCT. Now, what Rule 46 says is, the Lieutenant Governor shall exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons, that is one, or by any other order of the President in consultation with the Chief Minister, if it is so provided under any order issued by the President under Article 239. So there are two areas where the Lieutenant Governor can exercise any power in respect of persons serving in connection with the NCT. Only there must be a specific entrustment to him in the rules or conditions governing the service of that person, like all India service officer.
Correct.
Or if it is so provided in an order made by the President under Article 239. All right, and then also he has to act in consultation with the Chief Minister. So the only entrustment to the Lieutenant Governor in matters relating to service of persons serving in connection with the NCT is limited to 46.
46. And I'll have to show two things. A, the statutory rules, and B, the entrustment by the President.
239.
Correct?
That's true.
That's all.
That's right.
Now, 50. My Lord Justice Shah's, my Lord, a question. Where a case is referred to the central government, 50. In case difference of opinion between the Lieutenant Governor and the Council with regard to any matter, the Lieutenant Governor shall refer it to the central government for the decision of the President and shall act according to the decision of the President. Then President is final. First, this, my Lord, kind of a mediation exercise, mediation I am loosely, my Lord, calling, and if that fails and the dispute persists, the difference persists, then President is the final arbiter. Where 51, where a case is referred to the central government in pursuance of Rule 50, it shall be competent for the Lieutenant Governor to direct that action shall be suspended pending the decision of the President on such case, or in any case where the matter in his opinion is such that it is necessary that immediate action should be taken to give such direction. 52. Where a direction has been given by the Lieutenant Governor in pursuance of Rule 51, the Secretary of the Department concerned shall take action to give effect to such direction. He is bound. Then 53. In respect of each one, your lordships can skip. Come to 55. The Lieutenant Governor shall refer to the central government every legislative proposal. But this is the mandate of the Lieutenant Governor, not his discretion. Whether he differs or if he agrees. And see the subjects. Because it's a UT, but that apart more so because it's a capital of the country. But only for legislative proposals, not executive actions. the Lieutenant Governor shall refer to the central government every legislative proposal which, if introduced in a bill form and enacted by the Legislative Assembly, is required to be reserved for the consideration of the President under proviso to subclause 1C of clause 3 of Article 239AA, or as the case may be under second proviso to Section 24 of the Act. Well, there is something which turns on that on services also, and I'll refer to that. B, attracts provisions of Article 286, 287, 288, and 304 of the Constitution as applicable to the capital. C, relates to any matter which may ultimately necessitate additional financial assistance from the central government through substantive expenditure from the consolidated fund of the capital or abandonment of revenue or lowering of rate of any tax. Subject to any, because Lord, if suppose somebody says that I will not collect any tax and I'll draw everything from the consolidated fund of India, then Lord, the LG would say, wait, let the president decide. You can't do this. 2, subject to any instructions which may from time to time be issued by the central government, the Lieutenant Governor shall make a prior reference to the central government in the Ministry of Home Affairs or to appropriate ministry with a copy to the Ministry of Home Affairs in respect of following matters. A, proposals affecting the relations of central government with any state government, the Supreme Court of India, or any other high court. He doesn't have to wait. He has to make a prior reference to the president, and rightly so. The capital can't be in conflict with central government or the Supreme Court of India or the High Court of Delhi. Proposals for the appointment of Chief Secretary and Commissioner of Police, Secretary Home and Secretary Lands, for obvious reasons, my lord, those expressly excluded entries. Important cases which affect or are likely to affect the peace and tranquility of the National Capital Territory of Delhi. Cases which affect or are likely to affect the interests of any minority community, SC or STs. Last, my lord, is 57. The Chief Secretary and the Secretary of the department concerned are severally responsible for the careful observance of these rules, and when either of them considers that there has been any material instead of giving effect to such departure, he shall personally bring it to the notice of the Minister in charge, Chief Minister, and the Lieutenant Governor. If there is any deviation found by the Chief Secretary and the Secretary of the department, this is his responsibility. He will inform the Minister in charge, Chief Minister, and the Lieutenant Governor. This is how the Delhi as a model, as a unit of governance of the capital, not function. Not every country has its own sui generis system of governance, because every country has different geopolitical situations which are different. Lord, why we have, Lord, I am asking a fundamental question to myself. Why can't we have only states? Why do we have, Lord, union territories? Because for some strategic reasons, some areas are advisedly found to be directly under the control of Union of India. But Div Daman, for example, there is a tremendous navy presence for some strategic defense reasons. Cannot be a state, but it has to be under the administration of the Union directly. Delhi, it's a capital of the country. It's a wisdom of the constitutional makers that Andaman and Nicobar Islands. There are certain strategic issues where the constitution felt that it should be directly under the control of the central government, not the state government. And therefore, Lord, Delhi is given an additional administrative infrastructure. Otherwise, except in Puducherry, there is no legislative assembly. It's like, it's an extension. Lord, Delhi ultimately is an extension of the union. Union territories in general are not essentially extension of the union, and therefore your lordships would notice, Lord, 239 AB. 239 AB. Kindly immediately come to the next point, Lord.
You can come to the next point, 2 more points.
The solicitor will continue tomorrow morning. We'll come to you.
Lord, I assure your lordships, I will not repeat anything. I will not be irrelevant, Lord, but let me not be under the pressure of Lord time, because I'll not, I know, my lord, the time of 5 honorable judges, my lord,
You can never be under the pressure of anybody.
I'm.
Time to vary the.
Obliged to your lordship.